Committee will come to order. Would you please close the doors? Thank you. The Oversight Committee exists to secure two fundamental principles. First, Americans have a right to know the money Washington takes from them is well spent. And second, America deserves an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to be accountable to taxpayers, because taxpayers have a right to know what they get from their government. It's our job to work tirelessly in partnership with citizens watchdogs to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. It's now my privilege to recognize the ranking member for the opening statement.
Thank you very much, Mr. Chairman. Commissioner Koskinen, I want to thank you for being here this morning, and I want to thank you, Mr. Chairman, for calling this hearing. I think it's very important that we look at what the Inspector General for the Treasury recommended and take a look back at the research that he did. Nearly 1 year ago, the Treasury Inspector General for Tax Administration, Russell George, issued a report concluding that IRS employees used, and I quote, inappropriate criteria, end of quote, to identify tax-exempt applications for review. I want to revisit the findings of his report. The IG found that there was ineffective management, and that's a quote, at the IRS. The first line of the results section of the report said this began with employees in the determinations unit of the IRS office in Cincinnati. I didn't say that. The IG said that. The IG also went on to say that these employees, and I quote, developed and used inappropriate criteria to identify applications from organizations with the words Tea Party in their names, end of quote. The IG also said these employees, quote, developed and implemented inappropriate criteria in part due to insufficient oversight provided by management, end of quote. The IG report that former IRS official Lois Lerner did not disclose the use of these inappropriate criteria until 2011, a year after it began. Again, I didn't say that. The IG said that. Although, quote, she immediately, end of quote, ordered the practice to stop, the IG stated that employees began again using different inappropriate criteria, quote, without management knowledge, end of quote. In contrast, the Inspector General never found any evidence to support the central Republican accusations in this investigation, that this was a political collusion directed by or on behalf of the White House. Before our committee received a single document or interviewed one witness, Chairman Issa went on national television and said, and I quote, this was the targeting of the President's political enemies, effectively and lies about it during the election, end of quote. Similarly, Representative Al Rogers, the chairman of the Committee on Appropriations, stated on national television, and I quote, the enemies list of out of the White House that IRS was engaged in shutting down or trying to shut down the conservative political viewpoint across the country, an enemies list that rivals that of another president some time ago, end of quote. Representative Dave Camp, chairman of the Ways and Means Committee, said, and I quote, this appears to be just the latest example of a culture of cover-ups and political intimidation in this administration, end of quote. The Inspector General identified no evidence to support these wild political accusations. The IG reported that according to the interviews they conducted, the inappropriate criteria, and I quote, were not influenced by any individual or organization outside the IRS. The IG testified before this committee that his own chief investigator reviewed more than 5,500 emails and found no evidence of any political motivation in the actions of the IRS employees. Rather than continuing this partisan search for non-existent connections to the White House, I believe the committee should focus squarely on the recommendations made by the Inspector General. The IG made 9 recommendations in his report last May. As of February of this year, The IRS now reports that it has completed all 9. For example, the IG recommended that the IRS change its screening and approval process for tax-exempt applications. In response, the IRS ended the end of so-called be on the lookout list and developed new guidance and training. The IG also recommended that the IRS ensure that applicants are, quote, approved or denied expeditiously. In response, the IRS made significant progress on its backlog over the past year, closing 87% of these cases. As I close, I want to thank the Commissioner and his predecessor, Danny Werfel, for their extraordinary cooperation with Congress. I completely disagree with the Chairman's letter yesterday complaining about the agency's so-called failure to produce documents and its noncompliance with committee requests. Nothing could be further from the truth. More than 250 IRS employees have spent nearly 100,000 hours responding to congressional requests. They have delivered more than 420,000 pages of documents to this committee, and they have spent at least $14 million in doing so. Chairman's statements simply disregard these facts. They're also at odds with Chairman Camp of the Ways and Means Committee, who issued a press release just this month praising IRS for its cooperation with document requests as a, and I quote, significant step forward. Commissioner, I wanted to thank you for your efforts during this investigation and for your exceptional cooperation. And I want to thank all of those IRS employees who are working so hard and tirelessly to do their jobs. And with that, Mr. Chairman, I thank you, and I yield back.
Thank the gentleman. I am pleased to welcome our witness, Commissioner John Costigan. He was appointed by the President to restore trust and accountability to the IRS. Commissioner, you have a difficult task ahead of you. The American people do not have, and my opening statement says, any faith, but they certainly don't have the faith they once had in the IRS to be truly a nonpartisan, nonpolitical tax collector, and rightfully so. Does nonpartisan, nonpolitical agency target certain groups based on their names or political ideology? The IRS did. Does a nonpartisan or nonpolitical agency conspire to leak the findings of an independent Inspector General report? The IRS did. Does a nonpartisan, nonpolitical agency withhold documents requested during a congressional investigation subject to a lawful subpoena? The IRS does, did, and continues to. Does a nonpartisan, nonpolitical agency reinterpret laws protecting taxpayer information when it appears their employees violated the law? The IRS does. Does a nonpartisan, nonpolitical agency blatantly ignore a congressional subpoena? Again, the IRS continues to. The American people believe the IRS is now a politicized agency because the IRS is a politicized agency. Our constituents deserve better than this, Commissioner. You are the President's man at the IRS. You are one of only 2 political appointees. But it's clear that individuals acted on their politics, and we now have some, but only some, of the emails to prove it. You were brought in to do a very hard job, and no doubt you ask yourself every day, why did I get and ask for and accept one of the hardest jobs anyone could ever have in Washington? And I appreciate that you are there and that you want to do that job. One of the ways you could do it is by ordering your people to simply comply with outstanding subpoenas. The simple fact is your response to the IRS targeting scandal has been bold by the ranking member standard and dismal by my standard. This committee doesn't count how many documents are produced, but we do count when documents clearly responsive to a subpoena are clearly not delivered. The committee has made, has made document requests almost 11 months ago that are still unfulfilled. I issued 2 subpoenas, the second to you personally, and they're still outstanding, and this is unacceptable. Unfortunately, you've been more concerned with managing the political fallout than cooperating with Congress, or at least this committee. I requested that you produce all of Lois Lerner's emails to this committee. She won't talk to us, so these emails are the next best substitute, and we need these emails, and you know we are not only entitled to them, but by all that is holy, we deserve, and the American people deserve, access to know why somebody who cites Citizens United, who cites political gains, including the outcome of Senate majorities, who cites in a public speech statements about we need to fix it because the FEC can't do it, who cites they want us to do it, and then takes the fifth when we ask who they are. Those emails, in their entirety, are clearly responsive. These are easy requests, and one that were made back in May, but have not been honored, and that request is one that you said you would work to fully comply. I understand you reached an agreement with the Ways and Means Committee to produce a limited subset of Ms. Lerner's emails. Let me make it very clear. Your agreement with Ways and Means, without a subpoena, does not satisfy your obligation under a subpoena to produce all of her emails to this committee. Commissioner, your objection or your refusal to cooperate with the committee delays bringing the truth, cost the American people the confidence they hope to rebuild, and clearly is running up the cost to the American taxpayer. I know you want to bring this investigation to a close as soon as possible, and I do too. But the only way you can do that is to fully comply with our request, and I hope you will take that to heart today. And I yield back. I now recognize the gentleman from Ohio for his opening statement.
Thank you, Mr. Chairman. I'd like to try to provide a little context for today's hearing. Let's go back to January 2010. The President of the United States, in his State of the Union address, called out the Supreme Court regarding the Citizens United decision. That same year, 2010, the President numerous times talked about Tea Party groups as shadowy groups who would hurt our democracy. That same year, Senator Schumer says we're going to get to the bottom of this, encourages the IRS to investigate. Senator Baucus, that same year, asked the IRS to investigate C4 applications and C4 groups. Senator Durbin asked the IRS to investigate Crossroads GPS. And then, in that same year, 2010, 2 weeks before the election, October 19th, at Duke University, Lois Lerner gives a speech, and she says this: the Supreme Court dealt a huge blow in the Citizens United decision, and everyone is up in arms because they don't like it. They want the IRS to fix the problem. The IRS laws are not set up to fix the problem. C4s can do straight political activity. So everybody is screaming at us right now. Who's everybody? Everybody is not everybody. Everybody is the President and Democrat senators who ask her to do something. Fix it now before the election. Lois Lerner says, I can't do anything right now. She couldn't fix it before the 2010 midterm election, but what she could do is start a project to deal with it in the future, and that's exactly what she did. That same fall, she sent an email, again, just weeks before the midterm election. Lerner tells her colleagues, let's do a C4 project next year. But she also says we need to be cautious so it isn't a per se political project. In fact, Mr. the chairman put this email up at our last hearing. Per se political project means that's code for it is a political project. We just have to make it look like it's not a political project. Then in early 2011, Lois Lerner orders the multi-tiered review of C4 applications. Multi-tiered review, you know what that is? That's code for we're going to delay, we're going to harass, we're never going to approve these people, we're going to make it difficult. That's part of the C4 project. And then make no mistake, she put Washington in charge. This email is also one that the chairman put up at our last meeting, where Lois Lerner said this in February of 2011. Tea Party matter, very dangerous. Cincy should probably not have these cases. So this narrative about Cincinnati line agents in Cincinnati doing this is completely false. She ordered them not to have these cases, and then what happened? Lois Lerner got caught with her hand in the cookie jar. Tea Party groups came to us and said, we're being harassed. We asked for the Inspector General to do an investigation. He did the audit, and then before he can release the audit, unprecedented, before he releases the audit, Lois Lerner, in a speech in front of the Bar Association here in this town, with a planted question from a friend, reveals that, yes, targeting was taking place. And what'd she do? She throws the Cincinnati people under the bus. The very people she said shouldn't have the cases, she throws them, good civil servants, she throws them under the bus. And here's the real kicker. Lois Lerner, who did this project from the pressure from the president and Democrat senators who did this project, she won't talk to us. She won't talk to us, and our witness today won't give us her emails, even though we subpoenaed them over 6 months ago. That's what, Mr. Chairman, Lois Lerner won't talk to us. She'll talk to the Justice Department because she knows that investigation. She'll talk to the people who can put her in jail, but she won't talk to us, and the guy who can give us the emails won't give us the emails. And here's why today's hearing is so important. The C4 rule that's being proposed, that got 149,000 comments, would codify what Lois Lerner put into practice, would in fact accomplish the goal that she set out to do in 2010. The C4 rule, well, we had a hearing 3 weeks ago, Mr. Chairman. We had a hearing 3 weeks ago where we had the ACLU, Tea Party Patriots, the Motorcyclists Association of America, and the Homeschool Legal Defense. All 4 of those groups came to that hearing, and you know what they all said? This rule stinks and should be thrown out. Now think about that. From the ACLU to the Tea Party, from homeschoolers to Harley riders, everyone knows this rule stinks. Everyone knows except the IRS. And now today, we get a chance, finally, to question the guy in charge of this rule, running this agency. Here's the final thing, Mr. Chairman, I'll yield back. The same people who pressured Lois Lerner to fix the problem are the same people who picked John Koskinen to finish the job. That's where we're at. And all we're asking is, give us the emails. Throw this rule in the trash because everyone knows it. The only people who want this rule are this administration and the IRS. Everyone else knows this thing stinks. Everyone else knows it. And that's why today's hearing is so important, Mr. Chairman. With that, I yield back.
Thank the gentleman. We now recognize the gentleman from Virginia for an opening statement on behalf of Mr. Cartwright.
Thank you, Mr. Chairman. And Mr. Koskinen, welcome back. I remember working with you on Y2K, and you did a great job then, and I'm certainly hopeful you'll do a great job now. I certainly think you're a great choice to be the new commissioner of the IRS. In listening to statements from the other side of the aisle, one might think that the IRS has just stonewalled the Congress and has been completely uncooperative. And yet, since the release of the audit report, the IRS has produced 420,000 pages of documents to this committee, facilitated 32 interviews of current and former IRS employees, and testified at 6 separate hearings. That's not non-cooperation. In addition, on March 7th, 2014, Congressman Dave Camp, the chairman of the Ways and Means Committee, issued a press release commending the IRS on its cooperation with the committee, and in particular, its production of documents. He stated, and I quote, "This is a significant step forward and will help us complete the investigation." That cooperation included an agreement with the Ways and Means Committee in terms of which emails, in fact, would be provided. The chairman says he shares your goal, your desire to want to end this investigation, but he needs more cooperation. And I certainly take the chairman at his word. But one has this suspicion that some of our friends on the other side of the aisle, the last thing in the world they'd do is end this ongoing, if you can call it that, investigation, because it serves their political aims. Mr. Jordan just cited a panel we had. I was at that hearing, and one had the impression that this is all feeding the base. It's designed to get, you know, certain groups all riled up in time for a midterm election.
Will the gentleman yield? question?
I'm going to finish my statement, Mr. Jordan, as you were allowed to finish yours. And that the serious purpose of investigation seems to be lost in the mire and the muck. This committee, on a partisan vote, decided that a citizen who happened to work for IRS, not a heroic figure in this story, but a citizen protected by constitutional rights, had in fact waived her rights. A very dubious finding in light of long case history in the courts, going back to the McCarthy era, when people needed that Fifth Amendment to make sure they weren't entrapped by their own words, by star chambers, or by people willing to play fast and loose with facts and with the truth to make some political point. And the fact that you might be an unwitting victim, you're a casualty of war. None of my colleagues on this committee, of course, would engage in that kind of thing. But to strip an American citizen, or claim to strip an American citizen, of her Fifth Amendment right, a right that was enshrined as sacred by the founders, who had been treated to the tender, loving mercies of then British colonial justice. It stung so much that they wanted to protect every American citizen from that kind of treatment, even if they might be hiding something, even if they weren't heroic figures. Precisely why the Fifth Amendment was there. So, Mr. Koskinen, there are some of us here who wish you well and will certainly cooperate with you and try to make sure yours is a successful tenure. Obviously, to the extent that you can cooperate even more fully with this committee, that would be welcome. But be aware that unfortunately, this committee has a habit sometimes of cherry-picking facts and of leaking. I heard the chairman complain about the IRS actually leaking documents. My. That would be a terrible thing if true. Certainly not something we ever do in this committee. But just in case, be prepared, because that may happen to you too. So thank you for your cooperation, but be on your guard, because there's something else at work here. I yield back.
Members may have 7 days in which to submit opening statements for the record, including extraneous materials therein. The Chair now welcomes the Honorable John Koskinen, who is the Commissioner of the Internal Revenue Service. Welcome. Pursuant to the rules, all witnesses will be sworn. Would you please raise your right hand to take the oath? Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Please be seated. Let the record reflect the witness answered in the affirmative. You're a seasoned pro at this, and I will remind everyone your entire statement is in the record, and it's been distributed in the packets, and you may summarize as you see fit. You're recognized.
Thank you. Good morning, Chairman Issa, Ranking Member Cummings, members of the committee. Thank you for the opportunity to appear before you today to discuss IRS activities in regard to the determinations process for tax-exempt status. I am honored to serve as the IRS Commissioner and to have the opportunity to lead this agency and its dedicated employees, because I believe that the success of the IRS is vital for this country. One of my primary responsibilities as IRS Commissioner is to restore whatever public trust has been lost as a result of the management problems that came to light last year in regard to the application process for 501c4 status. Taxpayers need to be confident that the IRS will treat them fairly, no matter what their backgrounds, their affiliations, who they voted for in the last election. I am committed to ensuring we restore and maintain that trust. I'm pleased to report to you that the IRS has made significant progress in addressing the issues and concerns with the 50C4 determinations process. First of all, we've been responding to the recommendations made by the Treasury Inspector General for Tax Administration. It was the Inspector General's report in May of last year that found applications for 501c4 status had been screened using inappropriate criteria. As of late January of this year, we completed action on all 9 of the Inspector General's recommendations. Our actions have included reducing the inventory of 501c4 applications, including the group of 145 cases in the so-called priority backlog, that is, those that were pending for more than 120 days on or before May 2013. As of this month, 126 of those cases have been closed, including 98 that were approved. Of those 98, 43 took advantage of a self-certification procedure we offered last year. Also in response to the Inspector General, the Treasury and IRS issued proposed regulations in November that are intended to provide clarity in determining the extent to which 501c4 organizations may engage in political activity without endangering their tax-exempt status. As you know, we have received over 150,000 comments on that draft. Although I do not control by myself the rulemaking process, the Treasury and IRS have a long-standing history of working cooperatively in this regard, and I will do my best to ensure that any final regulation is fair to everyone, clear, and easy to administer. Along with the actions we've taken in response to the Inspector General, we continue to make every effort to cooperate with the 6 ongoing investigations into the 501c4 determinations process, including this committee's investigations. Over the last 18 months, the IRS has devoted significant resources to this committee's investigation and requests for information, as well as those of other congressional committees. More than 250 IRS employees have spent nearly 100,000 hours working directly on complying with the investigations at a direct cost of $8 million. We also had to add capacity to our computer systems to make sure we were protecting taxpayer information while processing these materials. We estimate that work cost another $6 million or more. To date, we have produced more than 690,000 pages of unredacted documents to the House Ways and Means Committee and the Senate Finance Committees, which have Section 6103 authority, which means they can see taxpayer information. We've already produced more than 420,000 pages of redacted documents to this committee and the Senate Permanent Committee on Subcommittee on Investigations. Last week, we were pleased to announce that we believe we have completed our productions to the Ways and Means and Finance Committees of all documents we have identified related to the processing and review of applications for tax-exempt status as described in the May 2013 Inspector General report. We are continuing to cooperate with this committee, and I would stress that. We are continuing to cooperate with this committee and others receiving redacted documents, and we will continue redacting and providing documents until that process is complete. As part of that process, it's my understanding that we will be delivering a substantial number of documents to this committee later today as part of the ongoing process. In light of those document productions, I hope that the investigations of the C4 determinations process can be concluded in the very near future. In the event that this committee would, at some point in the future, decide to investigate other matters pertaining to the C4 area, such as the rulemaking process or the examinations process, the IRS stands ready to cooperate with you. Mr. Chairman, that concludes my statement. I would be happy to take your questions.
Thank you. And I'll recognize myself for a round of questioning. Did you need to upgrade your computers in order to produce all of Lois Lerner's emails?
I'm sorry, could you?
Did you need to upgrade your computers to produce all of Lois Lerner's emails?
We have to upgrade our computers to produce all of the emails and documents.
Commissioner, I appreciate that, and my time is limited. I recently pulled all of my emails off of the House computers. It took one person at House Call a very small part of a morning to gin it up and produce it. I understand it takes a while to go through them, but if I'm correct, in a matter of hours, not after we subpoenaed, but after we showed interest, your agency had taken all of Lois Lerner's, all of Holly Paw's, all of William Wilkins, all of Jonathan Davis, former Chief of Staff, all of the White, or maybe not all of them pertaining to the White House, but the first 4 take a matter of minutes to do. So my question is, our subpoena, which is not extensive, for those 4 particularly, asked for information, asked for all the emails that somebody who has, in the emails we've seen, both government and non-government emails in some cases, acted overtly political in her speeches and her activities, including what Mr. Jordan quoted. We asked for all of her emails. Do you have any privilege or any reason that you can't and shouldn't have delivered that months ago?
You seem to have more information about this than I do. We have 90,000 employees, and my understanding of the process is that to go through all of those emails, which are millions of emails, to make sure we have not only the outgoing emails but the incoming emails is not a matter of a few minutes or a few hours. But in any event, we have provided for all of those people, or in the process of providing, all of the information and all of the emails related to the determinations process, and we have...
Commissioner, that is not the subpoena. And I want to be very clear. We issued you lawful subpoenas because you didn't cooperate based on letters. Our subpoena says all of Lois Lerner's emails. Is it your position today that you intend to give us those responsive to some key search word, or you intend to give us all of Lois Lerner's emails, all of Holly Paz's emails, all of William Wilkins's emails, all of Jonathan Davis's emails?
We are working through the process. We have never said we would not provide those. We are anxious, as I have said.
Will you provide all of the emails for those 4 individuals?
We will provide you. We are actually trying to, in an orderly way, conclude the investigation on the determination process, which is what the IG report reported to. We've had over 250 people at various times working on this investigation. We are producing emails. You will get email copies today, redacted, and you will continue to get them. Our hope is that you could concentrate on the determination process. GAO is already at the congressional request doing a review, starting a review on the examination process. As I've said in my letters to you,
No, Commissioner, you said something, and I want to focus on that. You said your hope is that we would focus on the determination process.
I can't tell you what to focus on. It's
Thank you. We are focusing on those individuals. We have asked for all of their emails in a legal subpoena. My question to you today, will you commit here today to provide all of the emails? Not all the emails you believe are responsive, not all the emails you choose to give, not all the emails that are other than embarrassing, all of the emails.
Mr. Chairman, we are prepared to continue to work with your staff. As you can understand, when you say all of the emails, you're going to get hundreds of thousands of pages of irrelevant documents.
No, I'm sorry. Lois Lerner is an individual. We're asking for all of her emails. She obviously had a limited amount of emails. Quite frankly, we asked for all the emails. We believe that the emails, for example, where she talked about the outcome of the Senate races, maintaining Democratic control because of Indiana and other states, the outcome of the Maryland pro-gay initiative, all of those are responsive to who she was and why she did what she did. Therefore, we have asked for, in the case of these individuals, all of their emails. Holly Paz, for example, said she didn't know what Citizens United was. Well, Lois Lerner made it clear that she was trying to find a way to enforce around Citizens United at the IRS, and we've already seen the documents for that. Will you today commit to deliver all of the emails, not all that you think are responsive, all that the 4 squares that any lawyer can read of the subpoena says we're asking for, which is all the emails for Lois Lerner, all the emails for Holly Paz, all the emails for William Davis, and all the emails for Wilkins, and Jonathan Davis. Now, these are all of the ins and outs from their mailboxes. It's not difficult. You already have pulled them. There's no question at all. It's a question of will you deliver them.
Mr. Chairman, we're happy to continue to work with you, and we will advise you. I'm not aware that we have pulled them all, but to the extent we have, they all have to be redacted, and we will work with you and advise you as to what the volume is. The reason the search terms were selected, they were selected by committee staff here and in the other investigations so that
your people, and my time has expired, you've previously selected search terms, asked us to give priorities. That's all fine. The subpoena that was personally delivered to you, which we expect you to comply with or potentially be held in contempt, those emails were very specific based on individuals who have become specific focus on why they did what they did and what they have said, whether it's true or not, is critical to this committee's discovery of intent. Will you commit to deliver all of those emails redacted only for 6103.
Yes, as I say, we've never said we wouldn't produce those emails. The search terms, just to clear the record, were not selected by the IRS. They were, in fact, selected in cooperation with the various congressional investigations on the House and Senate side to try to limit the volume of material you're going to get. We will be happy to provide you volumes of material.
My time has expired, but let me make it clear in closing. It does not take any search terms to respond to all the emails of Lois Lerner.
You're going to get a lot of emails, and as noted earlier, you may want to have this investigation go on forever. We have provided you all of the emails relevant to the IG report. We are providing you Lois Lerner's emails with regard to issues that you've raised about the examination process, about the appeals process, and about the regulatory process.
I appreciate that. The gentleman from, for what reasons, gentleman seek? Okay. The gentleman from Maryland.
Thank you very much, Mr. Chairman. I think the Chairman has asked a very good question, and I want to give you an opportunity to respond. So when you all are going through these emails, the last part of what you said is very significant. You said that you said something about they have to be relevant. I mean, where are you getting all of that from? You said you remember what you just said, the last part of it. It sounded like there were certain things that were used, terms that were used to decide what you think is responsive to the subpoena. Now, can you explain that to us?
Yes.
In other words, if she had a personal email and she was talking about shopping or something, I'm just, whatever. I mean, are you all separating? Is that part of the process? I don't understand.
Part of the process.
You said something about relevance. Can you explain that?
Part of the process when this started, because there are literally millions of emails, was to take a look at an agreement with the staffs of the investigating committees, take a look at 83. Ultimately, it was originally a smaller number. The IRS added to the custodians, as it were, that is, the people sending and receiving emails. There are 83 of those that we agreed to look at. The terms, in terms of what would be relevant, were determined by congressional committees as well as the IRS to try to limit the volume. As I say, limiting the volume, you still have 700,000 pages of relevant documents. To the extent that somebody wants to look at hundreds of thousands more pages of what the search terms defined by the Congress would be termed irrelevant, at some point we're happy to provide those. We will provide those in the orderly course. But I will tell you that our experience is it's going to be an overwhelming volume of materials that will take us some significant time to redact taxpayer information, a significant part of which will have nothing to do with this investigation. But if that's the way the committee wants to go, we will go that way. But the other committees and staff of this committee in the earlier determinations decided that that would be a fruitless task of overwhelming the investigators, not us, overwhelming the investigators with thousands of pages of irrelevant documents. Therefore, they suggested with us and selected with us search terms of what would be relevant. Tea Party, examinations, whatever else they picked. There are a whole series of those terms designed to limit the volume of materials. We still have provided a lot of duplicative and probably irrelevant materials within those search terms, but we have not determined anything within those search terms. We've said if those are the terms that will help you winnow it down, we're happy to work with you. But if the committee wants to get simply large volumes of personal emails from a lot of different people, we will go through, again, making sure that we redact those appropriately. As I say, we've provided unredacted copies of all of this in terms of the relevance determined by the committees to the other committees, and we provided all of the redacted information available now, and we're continuing to redact it. It cannot be done overnight.
Thank you very much. I want to go to the recommendations of the Inspector General, because this is oversight and government reform, and I think the committee ought to take some credit for what you have said, that there were 9 recommendations, and apparently you all have been able to address all 9 of that. We don't hear that quite often in this committee, by the way. So the Inspector General's report, which was issued in May of last year, made 9 recommendations. I have a chart here that lists each one of these 9 recommendations from the Inspector General. The title of the chart is Exempt Organizations Recommended Actions, ending February 24th, 2014. Do we have the chart? Mr. Chairman, I ask unanimous consent that this chart from the IRS be entered into the record.
Without objection, so ordered.
Commissioner, in addition to listing each of the 9 recommendations, this chart describes in detail the status of each recommendation. It describes the work that has been taken place over the last 10 months, as well as the specific reforms that were implemented. Is that correct? Are you familiar with the chart?
Yes.
If I'm reading this chart correctly, it appears that all 9 of the Inspector General's recommendations have been fulfilled. Is that right?
That's correct.
Let's look more closely at the status of these recommendations. The Inspector General first several recommendations began on page 10 of his report. They propose that the IRS change its procedures for how screeners in Cincinnati classify applications. All of these recommendations are now marked as completed. Commissioner, can you explain what new guidance the IRS has provided to screeners in Cincinnati about how they should classify and process these applications in an appropriate way?
Yes. The criteria for exemption under C4 are complicated because it's a, quote, facts and circumstance determination. The guidance and the new training has provided more guidance to those reviewing as to what's appropriate political advocacy and what is direct political campaign intervention. It's the campaign intervention that if it becomes your primary activity, you in fact are not eligible to be a 501c4. They are obviously complicated terms. We've provided better guidance, and we've also provided improved and new supervision for any determination that is going to be delayed. We also have provided clear lines of authority, so if anyone needs advice or additional assistance, they can get that automatically and easily.
On page 17 of the Inspector General's report, he lists another recommendation, and I quote, provide oversight to ensure that potential political cases, some of which have been in process for 3 years, are approved or denied expeditiously. In response, the IRS chart says that this, and I quote, as of February 21st, 2014, 112 cases in the original backlog, 85% have been closed. Commissioner, this is good news, and I understand from your testimony today that this number has gone even higher to 87%. Can you please explain how this expedited review process worked? I think I have 1 minute left on my time.
The one process, the way that worked is Interim Commissioner Danny Werfel, who I think did a great job as the interim, established a process for expedited review, and any applicant who would simply certify that they were not going to spend more than 40% of their time on political activity could be approved immediately. And that streamlined process continues for new applicants. 45 or so of the existing, at that time, pending applicants filed that paper and were immediately reviewed and approved. Of those that are still pending, they have decided not to, in fact, sign the affidavit that they would not spend more than 40% of their time on political activity.
My final question, I understand that the IRS has now completed all of the Inspector General's recommendations, but going forward, what additional plans do you have to ensure that these management problems have been fully addressed?
We have agreed with the Inspector General that as before any election, we will conduct additional training sessions and try to sensitize all of the people reviewing applications to make sure that we handle them appropriately, no matter what the political background of any of the organizations. And this would apply to people at one end of the spectrum, political spectrum, or the other. That will be done before every election as we go forward.
Thank you. And before I call another member, I want to make it clear, staff has informed me for the record that early on with the IRS, they did mutually agree to search terms. That was before the subpoenas were issued. There was never an assurance that those search terms were being used, and to this day, we don't know if those search terms were actually used. So one of the challenges is that was abandoned in favor of subpoenas because of what they believe to be noncompliance a number of months in. But there was an initial attempt to work cooperatively, but as I said, there was a question of whether or not those search terms ever actually got used. So thank you. We now go to the gentleman from Florida, Mr. Micah.
Well, thank you, Mr. Chairman. We've had an opportunity to interact in the past, and always appreciate your candor. At the very heart of this matter is a basic fact that IRS appears to have been used prior to the election, the presidential election, in a concerted effort to close down or keep at bay conservative organizations by targeting them. You're aware of that, sir?
I'm aware, as was noted earlier, that the Inspector General found inappropriate criteria were used to select organizations for further review.
Well,
he did not refer to it as targeted.
But you heard one of the principal IRS officials who was involved was Lois Lerner, who came to the chair where you're sitting now and took the Fifth Amendment. She's at the heart of most of this activity. It was pointed out by Mr. Jordan that she concocted, it was almost a Hollywood production before the Inspector General, May 14th, came out with his report to blame the people in Cincinnati, some rogue IRS employees who gathered around the water cooler and concocted a scheme to, again, go at target. And I think she laid that out. Is that not correct?
That's.
I mean, historically, you know that as a fact. She appeared before the American Bar Association, before the report came out, and made those statements, correct?
She did make those statements.
Okay.
I would note that because she took the Fifth, as I said in a letter to the chairman.
But again, this committee, and this, it's nice to be here for a while because you see how people try to throw people under the bus. Whether it's the chairman, you go back to Mr. Cummings said, here's, the case is closed. We started our investigation, and June 9th, in May, we started our investigation. June 9th, Mr. Cummings, the ranking member, said, here's, the case is closed. And then June 9th, well, he said, I've seen the case is solved, and if it were me, I'd wrap this case up and move on, to be frank. So he tries to throw the case under the bus. He tried to throw the chairman under the bus. He sent a letter just before that, your actions over the past 3 years do not reflect a responsible bipartisan approach to investigations. Now, he has a constitutional and a House responsibility for investigations and oversight. You have a responsibility to provide us with information. Now, we've asked you specifically for about a half a dozen individuals' emails, including Lois Lerner. Is that correct?
Yes.
Okay. And you said, you just testified to us, probably most of the, and you said you gave $640,000 to the Ways and Means and $420 to our committee. But you also said here, and we could play the tape back, probably most irrelevant material, right?
Most irrelevant material.
Probably mostly irrelevant material were your words.
Of the material we provided.
At great expense. And IRS and most bureaucracies have no problem spending lots of money doing things that we don't need. We asked you very specifically for the emails from six individuals, a half a dozen individuals, and you have not complied, including Lois Lerner. Is that correct?
My point was what you're going to get is mostly irrelevant.
I know, and we aren't interested in it. We're interested specifically in Lois Lerner and others to find out who did what. You're aware of Cindy Thomas's statements, and she was the chief person out in Cincinnati, and she said May 10th with a copy to Lois Lerner. We have a copy of that. To Lois Lerner with a copy to Holly. To Lois Lerner with a copy to Holly Potts. And she said Cincinnati wasn't publicly thrown under the bus. Instead, it was hit by a convoy of Mack trucks. Are you aware of her statement as to what took place?
I am. I'm aware of the fact that you already have a significant number of Lois Lerner emails, obviously, and in fact, we've been trying to.
But we don't have what we want. And again, it's a game of you providing us with probably huge amounts of irrelevant material.
That's what you're going to
And
get.
we're not interested in personal. You could give us a billion documents. That's not what we asked. We asked specifically.
Right. And what you're going to get, and I would like to.
Gentleman's time has expired, but you may answer.
Can I answer a question?
Of course.
sometime?
That's
Good.
why I said the gentleman's time has expired, but you may answer.
Thank you. Well, first of all, your earlier comment about your staff being concerned about whether the search terms were being followed is the first time I have heard that. We have followed those search terms. No other committee, none of the other 5 investigations going on have raised any question about whether we've in fact followed on those search terms. So if your staff has that concern, I would appreciate it if they would let us know, because none of the other 5 commission investigations and none of the other 5 staffs have raised that issue. And as far as I know, we have abided by those search terms and provided everything that the committees requested pursuant to those search terms and with regard to the determination process. With regard to Lois Lerner, as I said in my letter to you, because you have not been able to cross-examine her, because she is not an IRS employee, the first priority we have, we've already been providing you the emails. In fact, your staff report cited a number of them. You've had her emails with regard to the determination process. You've been able to cross-examine over 30 witnesses about anything you wanted to talk to them about. But because you could not talk to Lois, we are providing you, and they have to be redacted, we are going to provide you Lois Lerner emails with regard to not only the ones you have about determinations, but Lois Lerner emails with regard to the examination process, the appeals process, and to the extent there are any with regard to the development of the proposed regulations that were issued. Those were the issues that have been raised, concerns about what her involvement was. We've committed that we will provide those to you. We've prioritized. We have not said we're not going to provide you the rest of them. We have prioritized trying to complete document production so that we would be able to get you the information that we thought would be appropriate for the determination process. As I said in my letter to you, if you now want to actually run an investigation of the other areas with those employees or others, we're prepared to work with you. As you say, if you just want all the documents, once redacted, no matter what they are, we can give those to you, but I can guarantee you that you're going to go under, and it's not going to further the investigative process. But if that's the way you would like to do it, that will be our next priority.
Mr. Chairman, a quick unanimous request. I'd like this email from Cindy Thomas to appear in the record at this point in the proceedings, and also a copy of the Washington Post June 9th case is closed article to appear in the record.
Without objection, so ordered.
Mr. Chairman, unanimous. Mr. Chairman,
Yes,
unanimous request, just for a minute.
the gentleman's recognized.
He just said something, Mr. Chairman, and I want to make sure it's clear. It sounds like, Mr. Chairman, that he has an impression of what's being subpoenaed using certain lists, and we have an opinion, and they don't coincide. Is that accurate?
No, I think what's happened is the subpoena that was delivered to me in February said it wanted all the emails for a set of people. What we have been trying to do is all of those people, you have emails from those people with regard to the determination process pursuant to the search terms that we've been working with. This subpoena now says we'd like them all for anything. We have now finally completed, although we're still working on the redaction, all of the production of documents regarding the determination process, which is what the IG report focused on. We have said that that's the first priority we've had. We have never said we're not going to provide you the rest of the documents. And in fact, trying to figure out the most efficient way to do it, we've said we will provide you Lois Lerner emails on everything with regard to examinations, appeals, and the regulatory process as it goes forward. And I've said, when we're done with all of that, if you want to actually get emails, if you want them all, we'll give them all to you. But if you want to actually take a more focused investigation on the regulatory process or otherwise, we're happy to work with you to figure out how that goes. But in light of this chairman's view, as soon as we can finish the rest of these redactions and go forward, we'll provide you volumes of emails, which are many of them going to be irrelevant, which is what I said in Congressman Mica's comment. Not that the materials you have are irrelevant. The ones you're likely to get in volume are irrelevant. And if you want it without any selective process, we'll redact them. There's going to be thousands of pages, and we're happy to provide them to you. But it's not going to expedite the conclusion of this investigation. And as I say, a significant part of it's going to be irrelevant.
Thank you very much, Mr. Chairman.
For the gentleman, because it's a good question, one of the reasons that we requested all is that back when we were in the minority, we began digitally evaluating this kind of information, And when we have all, and the ones that the Commissioner was talking about, if they're irrelevant, then quite frankly, there's no redaction, because if they don't have 6103, there's no redaction appropriate. If that's the case, we do search terms and we look at only what we need to look at, but we can constantly search and research to try to get to the bottom of it. As you can imagine, we would not have found Lois Lerner talking to her daughter about overtly partisan political activity if we had only looked for determination. It wasn't relative to determination, but it was relative to possible motivation. The IG, as you know, wasn't aware of the speech at Duke University, in which it was clear that Lois Lerner was saying in pretty plain terms that she was going to act on what the FEC couldn't act on. So this is part of the investigation. It's the reason we've asked for all, and quite frankly, it takes a lot less time to just go through and view these things and say, oh, that's got no 6103, and you just start sending it. And that's what we had hoped for when we issued the subpoenas for all, because these are people, as you know, who have said things before a committee, or failed to say things in some cases, in which they become what law enforcement might call a person of interest. And Lois Lerner and Holly Paz and so on, and the other individuals are people of interest because of their possible role.
So in other words, any email with anybody talking to their daughter, if there's any relevance whatsoever, if they say, I just don't like Democrats, I mean, and say that was in any way you could connect that with an investigation, and they're talking to their daughter.
I appreciate that. But
I'm just trying to make sure I understand
But I just want to make sure the context.
Yeah.
These are government emails from a government account, back in and out. This is the use of IRS assets to communicate. We would presume that the majority of it is not shopping online. As a matter of fact, in the case of Lois Lerner, she did her shopping online in a Hotmail account, which she also did 6103 material on. So, you know, in a normal case, this would not be something you'd look through, but we and the Department of Justice, if they're actually doing the investigation they claim to, we have an obligation to look and figure out whether we can opt out these communications, which in this case were always the product of the government, always available, and as you know, it is a given that communication on government computers is in fact open to government review.
I just wanted to make sure the public understands that.
Thank you. Mr. Connolly.
Thank you, Mr. Chairman. I would say to the ranking member, it sounds like his understanding is correct, and I would hope we'd do the same with, I don't know, the IG, Mr. Russell George. I'd like to see all of his overt partisan political emails. I'd like to see if he's emailed relatives, if he's emailed staff members of this committee. I think that would be relevant to putting in context his findings and to determining whether he, in fact, is an objective source of information and analysis. But that's a different matter. Mr. Koskinen, as I read the Declaration of Independence, it's written largely initially, the first draft by Thomas Jefferson, but it was subject to an editorial committee. He didn't like that. He thought his words were pretty good. And among those words were Americans were entitled to life, liberty. Now here the editorial committee did not act. He said, and the pursuit of happiness. But it sounds like some people would substitute for that an unfettered and unquestioned access to 501c3 and 501c4 tax-exempt status. Do you read that in the Declaration of Independence, Mr.
Never thought of it
Commissioner?
that way, but I don't read it that way.
No, it doesn't read that way. So it's not really an explicit entitlement or right. It's a process you have to qualify for. Is that correct?
Correct.
There are many different ways of trying to figure out how somebody qualifies and whether they qualify. Is that correct?
Yes.
And by and large, historically, IRS has had a standard operating procedure for determining that status, either 501c3 or 501c4 or other status. Is that correct?
Correct.
In this particular case, what we're all excited about is that a filter was created in a regional office that seemed to target people for their political views, both right and left, but apparently mostly right. Is that right?
They were, as noted, the inappropriate criteria are used, primarily the name of the organization, to select them for further review.
Now, one of the problems we've got here is an adverb. The word used in the statute is exclusively, a social welfare exclusively devoted to that purpose. Is that correct?
That's correct.
And yet, despite the fact that Congress wrote that adverb into the law, IRS took upon itself, long before your tenure, to actually interpret that meaning primarily. Is that correct?
That's correct.
Now, if I said to my spouse, honey, we have an exclusive relationship, and I mean by that 49%, I'd probably have problems in my relationship. To her and to me, exclusively means just you, all the time, 100%. So how in the world did we get to a situation where the IRS, on its own, outside of statutory authority, decided to interpret this as primarily? Because to me, that's part of the problem. Exclusively ought to mean exclusively, and if Congress wants to change that, we should change the law. But I don't remember Congress investing IRS with the authority to actually decide to interpret it radically different, not just, well, kind of a little fudge factor here. This is radically different, and it seems to me therein is the problem. Because clearly some of these organizations are not exclusively social welfare agents. I mean, clearly they're largely designed to be political, partisanly political, that concern the chairman has, overt partisan communication. And I share that concern. And all too many of these organizations hide under the umbrella of social welfare when in fact what they really mean is partisan political activity. Can you address this dilemma for me? How the IRS could possibly take the word exclusively and reinterpret it to mean mostly, sometimes just shy of 50%, primarily?
Needless to say, I wasn't around in 1959 when that regulation was issued by the IRS. One of the reasons in response to the Inspector General's recommendation that clarification be provided, that the draft regulations were issued for comment, was to in fact solicit discussions about what the definition of political activity ought to be, how much of it ought to be allowed before you jeopardize your tax exemption or are ineligible for a tax exemption, and to which organizations in the 501c complex should that be applied. The 150,000 comments address all three of those issues. The proposed draft was designed to, in fact, review and revisit with the public and with comments and with Congress exactly that issue. What should exclusively really mean?
Thank you. My time is up, Mr. Chairman. I certainly hope, after all the storm and drang of this issue, we actually might come together on a bipartisan basis.
I certainly hope so, and I hope the gentleman remembers that 501c4s are not tax exempt to the contributor, so they really are no different than any corporation that spends all of its money doing anything. But it is an interesting question of what social welfare was in 1959 and whether promoting a reduction in smoking or something else would have been considered political prior to the creation of the Federal Election Commission.
And you know, Mr. Chairman, if I may, just, to your point, we may even decide, frankly, look, let's just have a new category that if you want to be political and you want to hide who your donors are, hopefully you don't, there's this category, so that we're not playing, frankly, with words and in a sense, all being complicit in this disingenuous exercise. So I take the chairman's point and would add to it. Thank you.
I thank the gentleman. We now go to the gentleman from Ohio.
Thank you, Mr. Chairman. Mr. Koskinen, what part of all don't you and the IRS understand? You've said like 10 times now, if you give us all Lois Lerner's emails, we're going to get irrelevant information. Frankly, with all due respect, we don't care what you think is irrelevant. The committee has asked for every single I asked for it clear back in August from Danny Werfel, and he told me the same thing you did. We're trying, we're hoping, we're going to get there someday, sometime. We want them all. Because if you limit it to what you said earlier, to determinations, appeals, exams, and rulemaking, just those categories, What if there's an email from the White House that says, hey, an email to Lois Lerner says, hey, Lois, keep up the great work. We appreciate what you're doing. What if there's that kind of email? That wouldn't fit under the categories in the search terms that you're talking about. When we say all, we want every single email in the time period in the subpoena that was sent to you. Plain and simple. Now, let me ask you this. You agree with the TIGTA audit report that came out? You agree there were problems, and you're trying to comply with the TIGTA audit report. Is that accurate, Mr. Koskinen?
That's correct.
All right, I'd like to put up slide 1. These are inappropriate criteria and questions that were sent out to Tea Party groups that TIGTA identified as going too far, inappropriate things asked. Issues that are important to the organization and asked that the organization indicate positions regarding such issues, type of conversations you have in your meetings, inappropriate questions. You can see they're highlighted there. Second slide. This is Judith Kendall, email that she sent to Holly Paz. Judith Kendall, Senior Technical Advisor to Lois Lerner. Same list, talking about how these were inappropriate questions that were asked of Tea Party groups. Now we move to the proposed rule that's got so much controversy. I think approximately 150,000 comments, more comments than any other rule that the IRS has ever proposed. Is that accurate, Mr. Koskinen?
Actually, take all the comments for the last 7 years and double them, and you get to that number.
Yes. So, and is it fair to say the vast majority of those comments are negative?
I have no idea. They're being analyzed right
Based
now.
on what we have heard, based on the hearing we had just a few weeks ago where we had the ACLU and the Tea Party all saying this thing stinks and we shouldn't have it, vast majority of those, I'm going to hazard a guess, are negative comments. If we could go to the third slide now. Now this is a newsletter that came out just 3 weeks ago, IRS Exempt Organization Newsletter, March 4th, 2014. Are you familiar with this newsletter that goes out from the Exempt Organizations Division of the Internal Revenue Service?
I do not see those.
Okay. Well, this is put out by the Exempt Organizations Division, same division where all these problems took place over the last 3 years. It came out, again, just 5 days after the comment period on the proposed rule ended at the end of February. And I want to just highlight a few of the questions that are asked. So there's a category that says, what if the IRS needs more information about your C4 application? New sample questions. So if we could put up the side by side. Now the first side are the targeted questions that TIGTA said were inappropriate and that you agree are inappropriate. Judith Kendall agreed are inappropriate. Those are those questions. And now, just 5 days after the proposed rule comment period ends, you issue a newsletter from the Exempt Organizations Division highlighting the new questions you're going to ask. And I just want to look how similar the two questions are. Let's just take the second category, whether an officer, director, et cetera, has run or will run for public office. The new question says this: do you support a candidate for public office who is one of your founders, officers, or board members? Same thing. I mean, it's basically the same. This reminds me of when I was in grade school and the teachers told us you shouldn't plagiarize, and so you change a few words, and you say, and basically plagiarize. This is the same thing. So here's what I don't understand. If you're trying to comply with the TIGTA report, if the new C4 rule is a way to deal with what the audit said and not what I believe, is a continuation of the project Lois Lerner started, why are you asking the same darn questions?
As I noted, I haven't seen that and can't read it on the chart. I would be delighted to go sit down and go over all of those questions with you and with the Exempt Organization. All of the TIGTA report didn't blanket say you should never ask questions about this. Thank you for the chart.
Let me read from your testimony, Mr. Koskinen. Page 7 of your testimony you submitted to the committee yesterday, talking about our notice of proposed rulemaking is consistent with the TIGTA recommendations. You said this in your testimony you gave the committee.
Well, okay.
And yet, consistent with TIGTA recommendations, TIGTA said these kind of questions are inappropriate. And now, just 3 weeks ago, Exempt Organizations Division issues a newsletter where you're asking almost verbatim, few word changes so you don't look just like you're totally plagiarizing or doing the exact same question, almost verbatim, the same darn questions.
I don't think they're. The first question says, provide a list of all issues that are important to your organization and indicate your position regarding those. The new question says, describe how you prepare voter guides.
What do you think voter guides are about? They're about issues. They're about the issues important to the organization. It's the same thing. Have you ever seen a voter guide? I have.
would
I've answered
submit-
those questions.
I would submit, and I appreciate
As a candidate for office, I've answered those.
I would submit, and I appreciate having a copy of this, that if I look at the first question and the revision is very different than the
Very
question.
different.
Very different.
Oh,
I look
yeah,
at
right.
the third question, what type of conversations and discussions did your members and participants have during the activity? That is now, describe how you determined what questions to ask of candidates. Doesn't say anything about what discussions or conversations your member had. It's including the scope of
You
the
think they don't
subject matter.
discuss it?
Doesn't ask for your conversation. It doesn't
Okay,
say what
okay.
your participants
All right,
are.
you
It specifically says.
You defend that.
Can I-
You defend that, and you defend the statement that you're complying with our notice for rulemaking, proposed rulemaking is consistent with the TIGTA recommendations. I don't think it is. And what I know is the same day this comes out, you send me a letter, our primary goal, same day, March 4th, 2014, letter to me, you responded to a letter we had sent to you. One of my primary goals and responsibilities is to restore whatever public trust has been lost over the course of the last several months. And yet you're asking almost the same questions that your people said were inappropriate to ask Tea Party groups when all the targeting took place. And now, as a response to the new C4 rule, we've changed the questions a little bit.
I think if you ask an organization independently, which are the questions, have there been changes? I think that these are new questions. They do not probe the discussions you had, the conversations you had. They didn't disclose your position on the issues. These are, in fact, new questions. Now, we may have a difference.
I
That's fine.
just disagree, and I think the vast majority of people who were harassed over the last 3 years would agree with my position. With
I'm
that, Mr.
happy
Chairman, I
to have
yield back.
these. I'm happy to have this in the record and let the public decide whether or not we've responded appropriately.
Oh, let me ask you one other question.
The gentleman's time has expired. I apologize. We now go to the gentleman from Missouri, Mr. Clay.
Thank you, Mr. Chairman. And Commissioner, the Chairman Issa wrote a letter to you yesterday complaining that you are guilty of a failure to comply with the committee's demands for documents. He also said, and I quote, "Your continued noncompliance with these requests also contravenes your pledge to fully cooperate with congressional investigations." So even though you have already produced more than 400,000 pages to the committee, even though you have 250 employees working on producing more, he accuses you of violating your pledge and frustrating congressional oversight. And I think this is shameful. And it's even more so when you actually look at the unbelievably broad demands the chairman has made. Let's look at just one of these demands. Number 8 in Mr. Issa's letter, it demands the following, and I quote, "All documents referring or relating to the evaluation of tax-exempt applications or the examination of tax-exempt organizations from January 1, 2009 to August 2nd, 2013. Let me read that again. All documents from 2009 to 2013, nearly 4 years, referring or relating in any way to tax-exempt applications. Mr. Commissioner, how broad is this request?
That request will get you not thousands, but probably millions of documents. The chairman has been focusing on emails, but you're exactly right. The full sweep of the subpoena will mean that we will be at this for months, if not years, collecting that information, redacting it, and then providing it.
Wow. Let me ask you this. The evaluation of tax-exempt applications is the function of the Exempt Organizations Division of the IRS. It is my understanding that about 800 people work in the division. Is that correct?
That's correct.
So the chairman has gone on national television and threatening you with contempt unless the IRS produces every document produced by 800 people over nearly a 4-year time period. Is that, Mr. Commissioner, even if you wanted to comply with this demand, how long would you estimate that it would take the IRS to complete this document production?
We've already spent 10 months, $15 million, and had 100,000 hours and 250 people working to produce the documents that we, in fact, agreed with the committee would be relevant. This is a much broader, more sweeping request to all of those documents, And I have continued to press our people, because I am anxious to get documents to the committees and investigators as fast as possible, how long it would take even to complete the redaction, and I cannot get a clear answer because it's a very complicated, difficult process. My guess is there's no way we would get you this information totally before the end of the year.
To me, this shows how our committee has moved from government oversight to government abuse. These ridiculous demands are not only overbroad and irrelevant, but they will force the IRS to continue wasting its precious staff and financial resources. This is about being reasonable and demanding documents within reason. And I don't get that sense from this committee that we're going in that direction. I think we're going in the opposite direction. To me, this is a partisan witch hunt, which has already cost the IRS more than $14 million. And compliance with these outrageous requests will only cause that number to continue to grow, and it certainly doesn't reflect good oversight, Mr. Chairman. I'm really appalled that this would that this investigation has gone to this level.
Would the gentleman yield?
I certainly do.
Do you feel that asking for all of Lois Lerner's emails so that we can search through to see whether or not she inappropriately was in fact actively doing more than we already know, do you think that's inappropriate?
I don't have a problem asking for Lois Lerner's email, but I do have a issue with asking for 800 people's emails. I mean, are all 800 connected to this investigation?
Well, like I say, we haven't received all of Lois Lerner's emails, which is one of the things we asked for.
Can we be more specific about what we're looking for Lois Lerner from her email?
No, we cannot. The gentleman's time has expired. We now go to the gentleman from Utah, Mr. Chaffetz.
Thank the Chairman. And Commissioner, thank you for being here. I have a copy of the subpoena that you were issued. You did receive the subpoena, correct?
Yes,
The date on this is February 14th.
correct.
You understand what it means? Is there any question that it was on what it means?
I don't think so.
Do you believe it was duly issued by the House of Representatives?
I'm assuming that. I have no independent basis for determining that.
The schedule, which is just 8 items, all communications sent or received by Lois Lerner from January 1st, 2009 to August 2nd, 2013. Is there any ambiguity in your mind? Do you have any doubt as to what that means?
No, if you want to go through all 8, I have no doubt what any of them mean. As noted, some of them mean that you're going to take months or years to get the information, and it's going to be voluminous.
Why?
There's no doubt about it.
So you have no ambiguity about what it means. You believe it's been a duly issued subpoena.
Right.
And you have not complied with it, is that correct?
There is physically no way anyone could have complied between February 14th and now. We have never said we won't comply. We have said, in fact, we're...
Well, are you going to comply or not?
We are complying, and I will tell you to comply
No,
with this. You'll be next year. You'll be next year still getting documents.
Commissioner, what email system do you use there at the IRS?
What email system
Yeah,
do
is
you
it
use?
Outlook, or you?
Yes, we have actually Microsoft. At least I have Microsoft Outlook.
So you have Microsoft. You go on there and you want to find all the items you sent under your name. How long would that take?
Well, it would take a while because they're not all on my computer. They're all stored somewhere.
Okay, so, but you're IT specialist. How long do you think it takes, of the 90-plus thousand employees there at the IRS, how long would it take to find all the emails that included her email address?
Just Lois Lerner's alone.
Just Lois Lerner. Just Lois Lerner.
It would take a while. We'd have to
Like how
search.
long?
Well, there are millions of emails.
Minutes?
A million minutes. I don't know, but I don't think it's minutes.
I mean, that's one of the brilliance of the email system is you go in and you check the sent box and the inbox, and you suddenly have all the emails, correct?
Right. They get taken off and stored in servers, and you've got 90,000 employees, and you've got...
I know, but I'm not asking to search. I'm asking to find one. They type in her email address.
We could find, and we in fact are searching, we can find Lois Lerner's emails.
And how long? How long would that take?
I have no idea how long.
Would it take a day?
As I just said, I have no idea.
Well, I just don't understand. You got a duly issued subpoena. If you were in the private sector and somebody was issued a subpoena and you didn't comply with it, what would happen to you?
For this subpoena, the court would actually rule that it's far too
Oh,
broad.
so you're
and
going to
we'd have
make
a
the
discussion.
determination.
No, the court,
You're going to make
you
the
asked the question. Let me answer the question. In a court of law, if you provided that subpoena, a judge would not enforce it because...
Wait, now stop right there.
Wait a
So
minute,
you're going to be the judge.
I'm not being the judge. I'm just telling you what would
Yes, you
happen.
are. Yes, you are.
You asked me...
You have a duly issued subpoena. Are you or are you not going to provide this committee the emails as indicated in this subpoena? Yes or no?
We have never said we wouldn't cooperate.
I'm asking you yes or no.
We are going to respond to the subpoena.
No, sir.
Yes, we are going to respond to the subpoena. I'm just telling you, to respond fully to the subpoena, we're going to be at this for years, not months. That's the only thing I'd like to...
And I don't understand that.
Pardon?
Just specific to item 1, Lois Lerner.
Lois Lerner...
Sir, are you or are you not going to provide this committee all of Lois Lerner's emails?
We are already
Yes
starting
or-
that process. Yes, we will do that.
Yes, and then by when? When can we have that?
I can only tell you, it's going to take me, my group, I asked this question the other day, just to get you the Lois Lerner emails, redacted, because you have to get them redacted, for examinations, appeals, and the...
No.
I'm just,
Is that what the subpoena says?
Would you like to hear the answer to that?
No, I'd like to know if you're going to fully comply with the subpoena, not your version of the subpoena, the
You asked
actual
me-
subpoena.
You asked me how long it would take to respond to the Lois Lerner emails. I'm explaining to you why it's going to take time, just to respond to the categorization.
I don't want you to redact
It's
it.
going to...
I don't want you to take the certain categories that you want. That's not what this duly issued subpoena says.
I am telling you, just to supply the Lois Lerner emails, which we are going to supply for examinations.
No.
Can I answer the question?
That's no, sir.
Okay.
When it says all emails, why are you qualifying that? Under what authority do you change this subpoena?
I was not qualifying. You were asking how long it was going to take, and I was giving you an example of why it's going to take a long time, because we have to redact out of those emails all of the 6103 information. We're working very hard to get you the Lois Lerner emails. It's going to take us several weeks to get you the Lois Lerner emails for examinations, appeals.
Wait.
The process.
Why are you getting us for just the, it'd be easier to just give them to us all, right?
I know it'd just take a lot longer because we have to redact the rest of them. They're there. We actually selected those because in a letter from the Ways and Means Committee also saying they need help, they focused on what they're looking for is those categories. So prioritizing, we said we'd provide both
The gentleman's
with those
time has
categories.
expired.
We're happy to provide you the rest of them. I just
Chairman,
want you to know it's
I'm
gonna
yielding
take time.
back, but this commissioner has no intention of fully complying with this duly issued subpoena. That's the case. That's where both of us, on both sides of the aisle, need to stand up for the integrity of the House of Representatives.
Chairman,
When you have a
Chairman.
duly issued subpoena, you
Chairman.
comply with it. It's not optional.
May I
Thank you,
simply-
gentlemen.
may I
I
simply
think
say that
no, that all time has
mischaracterizes the
expired.
discussion?
The gentleman from Maryland has
It's
a question.
unanimous consent, just for a minute.
Gentleman's unanimous consent, 1 minute.
Mr. Chairman, I never heard the commissioner say that he was not going to obey the subpoena. As a matter of fact, that's all he's been saying.
Actually, if the gentleman would yield, he has, on every single question, failed to say, yes, I will give you all the emails. He has gone into the ones that he is prepared to give, the ones that he could give to Ways and Means in an hour, because once you do the search, you just dump it to them. And even then he said that those would take, the ones that he says he's going to give us, he said it would take a couple weeks, and of course the subpoena is many months old.
There's
Well, let me just say, reclaiming just for a second. I just want us to be clear. I mean, time is precious, money is precious. Just tell us, I mean, you talk about relevance. You said if a lawyer were to see the subpoena, they would have some concerns. I just want them to be clear. I mean, It sounds like, again, I'm saying that what I said before. You seem to have an understanding, and we seem to have an understanding, and they don't seem to be the same. So are you going to provide the documents for Lois Lerner
Yes,
that were subpoenaed?
yes.
And how long will that take?
I do not know. I know it's going to take us several weeks. I asked that question yesterday, simply for the categories we're already working on, and I was told that to redact those will take us several weeks longer. It will take us much longer than that, but we will provide them. And I've said with regard, notwithstanding the congressman who's now departed, view that we're not going to comply. We are going to comply. We've said, and never said we wouldn't comply. We are simply trying to help refine the search so that, in fact, we could get this done sometime in the near future, that is this year. But at the rate we're going, if as noted by an earlier question, if you want all the categories of all the applications of everybody who's been through the C4 process for the last 4 years, we can do that and we will do that, but it's going to take years.
Very well. Thank you.
I thank the gentleman. I thank you for your questions. But hopefully we all understand that asking for all the emails, the ones that you seem to be least willing to put first, are the ones that probably have no 6103. They're very quick to go through, and somebody simply looks and says, oh, she's talking to an outside entity. By definition, there can't be any 6103 there, right?
Correct. All the ones that are easy. The ones that are difficult, and there are more of the difficult ones than we'd all like.
Right. And of course, the ones that the gentleman was asking for before he had to leave were the ones that were not being given, which by definition very often are easy.
Right. And I would just note for the record that all of the Lois emails we're talking about redacting have been provided already to the House Ways and Means Committee and the Senate Finance Committee because they don't have to be redacted. So there's been no question there about, in fact, the fulsome response.
Thank you. The gentleman from Massachusetts, Mr. Lynch.
Thank you, Mr. Chairman. Commissioner, just to take this from the top, the probative depth of our inquiry usually depends on the importance of the information that we seek and also the danger that we're trying to expunge. And I have to admit there's a deficit of trust here between the Congress, many of its members, and the IRS on this issue. And that is because on its face, there's been an admission here that the IRS, a very, very powerful government agency, has inappropriately targeted United States citizens for enhanced scrutiny, some would say harassment, and denial of statutory and constitutional rights based on their own political views. That's why my colleagues are after this information. That's why many of us on this side are after this information. So it's incredibly important. So when we say we need all of the emails in a normal circumstance, in a normal case, you might have a judge say that's overly broad. But in this case, whether the taxpayer was a Tea Party or was Occupy, whatever, a progressive group, the fact that the IRS, a very powerful agency with a lot of information on a lot of individuals here, is now targeting or has been targeting U.S. citizens, that's serious stuff. And I think that justifies the scope of this committee's inquiry and the urgency that we get to the bottom of this. Now, that's not just good for Republicans. That's not just good for Democrats. That's good for our democracy here. So this is a very, very serious issue. You know, in his seminal work, Congressional Government, President Woodrow Wilson described the oversight function of Congress as follows. He said, quite as important as legislation is vigilant oversight of the administration. It is the proper duty of a representative body to look diligently into every affair of government and talk much about what it sees. It is meant to be the eyes and the voice and to embody the wisdom and will of its constituency. In fulfillment of this solemn duty to inform the American people, it's imperative that we as legislators and members of this committee conduct robust oversight when we receive reports that a powerful government agency has subjected American citizens to excessive scrutiny based on unwarranted and unjust criteria, certainly no American citizen should have their constitutional and statutory rights withheld by the government on the basis of their political affiliation or simply because they've criticized the way that the government is being run. And any reports to that effect clearly warrant meaningful congressional oversight, and that's why I have, in the past and today, again, supported the extensive investigation conducted by this committee into the targeting of certain applicants for tax-exempt status. Now, regrettably, this investigation has thus far been guided primarily by politics and partisanship rather than a genuine commitment to fully inform the American people as to how these troubling events at the IRS unfolded. In particular, the Chairman has routinely released to the American public only partial excerpts of the transcripts from transcribed interviews conducted by both of our staffs with the relevant IRS officials. And most recently, the Chairman again released a staff report on the committee's investigation without first soliciting input from our side of the aisle after denying a request by our ranking member to share the report with Democratic members and minority staff prior to its release. So I understand the importance of this inquiry. I really do. I think it's incredibly important. But I also think that we have missed the opportunity here because of the Chairman's very partisan and one-sided approach to this hearing. And I think it's hurt the American people because I think it is incredibly important that we get to the bottom of this, but because it's being fumbled, this opportunity is being fumbled, we're not getting the answers that we need. But I do support the idea that our inquiries necessarily have to be very broad and deep because of the danger we're trying to excise here. We want to send a message to the IRS that you don't do this to our people. You do not do this to American citizens. You do not target people because of their political views or because they complain about the government. I complain about the government. I'm part of the government. So, you know, that is a precious freedom that we need to protect. And the IRS, in its recent approach, is threatening that very freedom. And that's a danger that we have to be together in opposing on both sides of the aisle. And I yield back the balance of my time.
I thank the gentleman. We now go to the gentleman from Michigan, Mr. Walberg.
I thank the Chairman. Mr. Koskinen, are you aware that your predecessor, Doug Shulman, in a testimony to Congress in March of 2012, gave very strong assurances that the IRS was not targeting conservative tax-exempt applicants?
I am aware of that.
Just for the record, his statement where he said, he testified, quote, "First, let me start by saying, yes, I can give you assurances. As you know, we pride ourselves on being a non-political, non-partisan organization, and so there is absolutely no targeting. This is the kind of back and forth that happens when people apply for 501c3 status." That was what he said. Do you think that Mr. Shulman's testimony was accurate?
I don't know what Mr. Shulman knew, what his relationship to the exempt organization department is, so
but was his statement accurate?
The statement may have been very accurate from the standpoint of what he knew. From the standpoint of the improper use of improper criteria, obviously, as the Inspector General noted, in the determination process, inappropriate criteria were used.
Was it complete and forthcoming as it should have been?
Again, I don't know what Mr. Shulman knew. What I've done is
from your perspective right now.
From my perspective, I have no way of knowing what he knew or didn't know.
From your perspective, was the information accurate? Not what he thought, but what you know right now.
From what I know right now, as a result of the IG report, I know that inappropriate criteria were used to select organizations for review in the determination process.
Can you give assurances, and I refer back to my colleague, Mr. Jordan from Ohio, when he listed a number of agencies and entities that have great concern about what has gone on with IRS that we know now took place, such as homeschool. I'm a homeschooler, my family. I'm a life member of the American Motorcycle Association. I'm a member of HOG, Harley Owners Group. I'm an NRA charter member. Tea Party caucus member here in Congress, a member of Right to Life, and I could go on with organizations, but my question says, can you give us assurances here and now that the IRS is no longer targeting conservatives or treating conservative groups differently than any other applicants?
I can give you assurances that I am committed, and I am confident the agency is committed to not discriminating against any organization or any individual, no matter what their organizational capacity, what their political beliefs are, who they voted for in the last election. If you deal with the IRS, you have a right, and I agree with the earlier comments, you have a right to assume, and you need to be protected to assume, that you're going to be treated the same way everyone else is treated. If
Absolutely, and our concern is that Mr. Schulman gave us that same certainty in his testimony in front of us.
I don't know how he ran the, ran the organization. I have just been to 16 of the largest 25 IRS offices. I have listened personally to over 7,000 employees, and my message to them has been that going forward, we need to have information flow from the bottom of the organization to the top, and if there's a problem, I need to know about it because
Great.
we'll fix it.
Let's go with that. Let's go with that testimony that you took.
Just to make you comfortable about it, if there's a problem, I don't know about it, then that's my fault, because that means I haven't created a culture where problems and issues get raised from frontline workers and go easily and freely.
What is the morale of the frontline workers now? Cincinnati and other places.
Morale actually is surprisingly better than I would have expected in light of what's happened to federal employees for 4 years and the IRS for the last year. I have found professional, dedicated, energetic employees focused on the mission of the agency. Their overriding concern is we don't have enough people to allow them to provide the services to taxpayers that they feel taxpayers deserve.
Well, they ought to feel that way because they were asked and they were put in situations that didn't allow them to do the job that they're expected to do, but rather to target conservative groups. I would be a low morale, and I'm glad to hear you say that it's coming up, but we've spoken with several IRS employees during the course of this investigation. They've told us that Lois Lerner's announcement that low-level people in Cincinnati were responsible for the conduct was a nuclear strike to them. And I'd assume that you would agree from what you've heard.
Yeah, it clearly, as I've told you, my view of running an organization, if there's a problem, it's my problem. It's not somebody else's problem. We'll work on it together. And my sense would never be that it's not my responsibility. Everything that happens in that organization is my responsibility.
I'm glad to hear that. And I just, again, question, with the difficulty in getting information, what are we hiding at the IRS? Mr. Chairman, I yield back.
I thank you. You answered a question partially, but the gentleman asked you is essentially, was it Cincinnati or was it Lois Lerner in Washington? Did you reach a conclusion on whether this was, in fact, low-level people at Cincinnati or, in fact, Lois Lerner and possibly others in Washington that were responsible for what effectively became targeting?
I haven't done an independent investigation. I've reached no conclusion about that. I'm looking forward to the reports from the various investigations.
But you agree with the IG's report, which found that essentially it wasn't low-level people in Cincinnati?
I've agree with the IG report in terms of the recommendations. In fact, in response to the earlier ones, I would stress to this committee that we have, in fact, adopted all of the IG recommendations. My commitment to people applying for applications now, whether it's a C4, C3, 5, 6, or 7, is that they will be treated fairly no matter who they are. It goes back to the earlier question. Whatever your political beliefs, whatever the name of your organization, you deserve to be treated fairly and on the same basis of everyone else.
If only that were true. Mr. Davis is recognized for 5 minutes.
Thank you very much, Mr. Chairman, and thank you, Commissioner. I know that we've hashed and rehashed and gone over and under the whole issue of the document requests, but I want to make sure that I understand as well as I can what the issues are here. The Chairman says that he wants all of Lois Lerner's emails, not just the ones related to C4s, not just the ones related to tax-exempt applications, but all of her emails. Obviously, this would include emails that have absolutely nothing to do with our investigation. In other words, the committee is going to what I would call the mat, and even threatening contempt for what everyone agrees are irrelevant emails. I don't think this makes any sense, and this is not what the Ways and Means Committee did. The Ways and Means Committee worked with you to identify the emails that are relevant to our investigation. Is that correct?
That's correct.
And if you are required to produce all her emails, you will have to examine each and every email for private taxpayer information covered by 6103.
That's correct. That's why we were able to provide the Finance Committee and the Ways and Means Committee with all those emails last week, and why it's going to take us several weeks to be able to provide the committee with her emails going forward.
And, of course, you cannot provide this committee with that information, and you will have to redact it.
That's correct.
If I understand this, by definition, the Internal Revenue Service will be wasting time and money producing documents that will not fulfill any investigative purpose. Would you say that is correct?
That's what we've been concerned about.
You know, I kind of grew up with the idea that you don't ride or you don't get much from riding a dead horse to death. That if he's already died, if everything that you can get out of him has been gotten, then you're wasting time to continue. I think that we should reconsider this misguided approach. We should go back to standard investigative procedures and develop search terms that are relevant instead of this other method, which appears to be nothing more than a fishing expedition, trying to connect some decisions to the White House or to some place that did not exist. I was very pleased to hear you indicate that the morale among IRS employees is at a level beyond which one might have expected. What would be the best utilization of your time to make sure that it stays where it is and goes up rather than being bowed down with an irrelevant investigation?
Well, I think one of the most important challenges we have, and we've been trying to do it with the 6 investigations going on, is to try to produce information as quickly as we can in an order that will allow the committees to and the investigators to conclude their investigation, because I think one of the important things for not only restoring public confidence in the IRS, but employee morale would be to come to closure on these issues. Whatever I have said from the start, whatever the facts are that each of the investigators find, we will review, we'll respond appropriately to, and move forward. No one has more interest in concluding these investigations promptly and in an orderly way than I do, and then the employees of the IRS, which is why we will continue. We've tried to provide information and work with the staffs of each of the investigators to provide the information they need in the most appropriate order, but ultimately, as I've said, whatever information the committee wants, they have a right to get. The question is, how long is that going to take, and can we get you the most relevant information at the front end so you can, in fact, do your work?
Thank you very much, and I yield back, Mr. Chairman.
I thank the gentleman. Recognize the gentleman from Tennessee. Could I have just 10 seconds of your time?
Yes, Chairman.
I might note for the record that in the case of Lois Lerner, we delayed bringing her back in hopes that we would get all the emails. And obviously, we didn't have them. She took the fifth 10 more times, and we're very disappointed. We made that very clear, that when you have somebody who has taken the fifth, I can't imagine a law enforcement agency or a judge saying that a subpoena relative to that person's government communication would be irrelevant. I thank the gentleman.
Thank you. Commissioner, thank you for being here today. We've had several commissioners in our presence since this story has broke. Commissioner Schulman, Commissioner Miller were two that would not acknowledge that wrongdoing had taken place, and they would not apologize to the American people for what had happened. Commissioner Wolferle did, or Danny Werfel did say that something wrong has gone on here and apologize to the American people. So I was encouraged to hear you say that what you know now, that you do believe that inappropriate criteria were used to target specific organizations. So at least we're to the point that we do acknowledge that something did go wrong, correct?
Yes, the inappropriate criteria were used. I don't think I used the word target, but I do acknowledge that applications were delayed unnecessarily and for too long.
Okay. Just a housekeeping item. I was back home in the district last week, and Rachel Killebrew, who's a treasurer of the McMinnville Breakfast Rotary Club, is sending a letter to the IRS to ask for a 501c3 organization, which will, among other things, help alleviate childhood hunger. I can tell her with confidence that you don't think their group will be targeted or delayed?
I can guarantee them they won't be, inappropriate criteria won't be used in any way. Delays are a different issue. One of our big challenges is, as a result of a lot of other things going on, we've built a backlog in the C3 area that we are aggressively dealing with. Our goal, ultimately, especially for smaller local organizations, is to have a streamlined process that will be up and running by June. Okay. So I can guarantee her she'll get appropriate consideration. I wish I could promise her right now it would be very quick. By the end of this year, we're going to be in much better shape in processing C3s.
I'll pass that along. I'm sure they'll be happy to hear that. Our colleague, Mr. Clay, earlier called this a political witch hunt. Do you agree with that?
I've made no judgments about any of these 6 investigations going on. I think it is important for the public to feel satisfied that there have been thorough investigations. Okay. I would like to see them concluded earlier rather than later. Sure. But we'll play the hand we're dealt.
All right. What do you think? Does it kind of handicap this process when officials from the Justice Department announced that that there would not be any criminal charges in this investigation? And this, of course, was before any of the witnesses had been questioned, or that the President goes on TV on Super Bowl Sunday and announces that there's not a smidgen of corruption within the IRS. Can you agree with either of those things, knowing what you know now and knowing that, depending on, I guess, how you define inappropriate tactics being used?
As I've noted in the past, I haven't done any independent investigation of what went on. There have been people across the political spectrum, in Congress, outside of the Congress, in this committee and other committees, making conjectures and judgments about what happened. My view is I'm waiting for the investigations to be completed. We'll respond to the facts and we'll proceed.
You heard my colleague, Mr. Jordan, in his opening statement. He laid out a pretty good timetable, I think, for anyone listening about how this has gone down. Do you understand the timetable that he gave, and does that give you a lot of concern?
I understand the timetable he gave. There's other information. You've got volumes of documents. What the purpose of a final report is that you would have a committee report. You would come up with facts as you found them. There may or may not might be a bipartisan report. There might be a dissenting report. We'll have several investigative reports. When they're done, we'll know what the consensus is what happened. More importantly, as I've said, it's important for the public to know we've adopted all of the IG recommendations. So whatever the management failings were that existed have been resolved.
I think we're getting a little gun-shy on this committee because this scandal, the Benghazi scandal, have been referred to as phony scandals. We know inappropriate targeting went on. I'm afraid if Hillary Clinton were sitting out there, she would probably look us in the eye and say, the President's always been reelected. At this point, what difference does it make? You're not going to be that way, are you?
I've never said it doesn't make any difference. My position is that this was a serious issue. It deserved to be treated seriously. The IRS has done that. I think, as a general matter, the investigators are doing that. As I say, again, my hope is that as soon as possible we can come to closure on it, agree on what the facts were. If there are additional things that need to be done, we will do them.
All right. Well, please get us the subpoenaed information. We can probably wrap this up much more quickly, and I thank you for your time.
Gentlelady from California is recognized.
Mr. Chairman, thank you. And Commissioner, thank you. You give me great confidence in the work that will be transpiring relative to this evaluation. You know, I must say, though, that when I think that $10 million has already been spent responding to inquiries by this committee, I'm curious at how much fraud could be unearthed within the persons within this country that don't play by the rules. No one likes the IRS. No one likes paying their taxes, but we do it. Most people follow the rules, but some people don't. And that's why you have an enforcement unit that for every dollar you spend there, you return $9 to the taxpayers of this country. I'm just speculating that if you had taken the 100,000 hours and 250 personnel that have been devoted all their time to complying with the endless requests by this committee, we might actually be doing some good in terms of the coffers that we're all so concerned about. But let me move on to the Inspector General's report. We have studied you to death over the last year. The Inspector General made a number of recommendations. My understanding is that you have complied with all of them. You've said that in this hearing a number of times. One of the concerns the Inspector General did have was that IRS employees did not have enough training and guidance to properly handle politically sensitive applications for tax exemption. And I'm curious, from your standpoint, what kind of training has now been provided to all of these personnel to make sure that they are properly trained?
We've provided training trying to give them better understanding about what's advocacy, which is allowed for social welfare organizations, and what's political intervention, which is only allowed to a minor amount unless you don't jeopardize being primarily a social welfare organization. And so there have been more cases developed, more examples developed so that people could understand better what's the dividing line between advocacy and political activity. I would note there are thousands of 501c4 organizations that aren't advocacy or political organizations. They're garden clubs and civic associations and a lot of other types. So the vast majority of C4s, in fact, aren't involved in this discussion. But the question has been for the training, especially for new employees or relatively young employees, to try to give them a better roadmap as to what fits into which categories and how they should be approaching any application, no matter what their political level of activity is.
So is this training also going to be provided to the screening agents?
Yes, it's actually provided across the board, and as the IG recommended, we will renew that training before every election, so that again, as political activity gins up before a campaign and election, people will have as clear a roadmap under a very foggy area as possible as to what's social welfare allowable activity and what's political activity, which if you engage in too much of it jeopardizes your tax exemption.
So this training has already taken place?
The preliminary training has already taken place, but the bulk of it will take place as we get closer again. So you'll get training. If you're a new employee now or an existing employee, that training has taken place. But as we get closer to the election, we'll do it again.
You know, Mr. Chairman, I just want to reiterate what I believe is the real problem here. The law that passed said that if you wanted to be a 501c4, you had to exclusively be associated with a social welfare activity. The word was exclusively. Then the IRS, back in the 50s, if I'm not mistaken, came up with a regulation that said that if you want to be a 501c4, you have to be primarily focused on social welfare. Now, that violated, in my view, the statute. It violated what Congress passed. How can you go from being exclusively to primarily? And so now we have expended millions upon millions of dollars trying to figure out whether or not something is primarily or exclusive. If we said the 501c4s should be exclusively for social welfare purposes, we wouldn't be having these hearings, because none of the political activity, whether it was advocacy or political, would be relevant because it wasn't exclusively for social welfare. And that's what 501c4 should be about. And I think that if we went back to redraw this, we would say the regulation did not meet the standard of the statute, and we wouldn't be having.
Would the gentlelady yield?
I certainly will.
I want to ask you just a quick question, because I agree with the gentlelady that we should try to clarify it. one of the challenges that I've faced looking at it, and it's not our committee's primary jurisdiction, it belongs to Ways and Means, but one of the things that I think we have to ask ourselves, for example, is, well, if a 501c3, like the American Lung Association, if they endorse a California initiative related to smoking and so on, which they did, is that at least a nuance of political, even though it's not partisan? And of course, the answer is no, they're promoting social welfare. One of the challenges with 501c4s, and Tea Party specifically, is these folks are walking around handing out constitutions and wanting to promote the Constitution. Many would say that's political, but if we go to evaluate it, is it political to say that this is what the First Amendment says and means? Is it political to say this is what the Second Amendment says and means? Or in the case of the NSA's activities, the Fourth Amendment? That's the challenge that hopefully the gentlelady and I can work on. Of course, the question of whether 501c4s were targeted because of their political views is, in fact, a different question, and that's what's before us today with the Commissioner. I thank the gentlelady for yielding.
The gentleman from South Carolina is recognized.
Thank you, Mr. Chairman. Commissioner, Lois Lerner sat where you're sitting right now and said, I have broken no laws, I have done nothing wrong, and I have violated no IRS rules or regulations. Now, as a very highly accomplished attorney like yourself, you would have to concede that's pretty broad testimony, wouldn't you?
That's a statement, whether it's broad testimony and what its relationship is to the...
No, it's broad. Your scope of cross-examination, if we'd been in trial, would have been unlimited. You mentioned a judge earlier, what a judge would do with this subpoena. Let me tell you what a judge would do with that testimony. You could ask just about whatever you wanted to ask. When a witness says, I've done nothing wrong, that is tantamount to saying, I've done everything right. I can't think of any testimony broader than that. So necessarily, our line of inquiry would also want to be broad. Wouldn't you agree?
I think your line of inquiry ought to be what it is, no matter what people have...
Well, no, you said a judge would throw our subpoena out, and I can't help but note you haven't moved to quash our subpoena, but you think a judge would throw our subpoena out as being overly broad.
If we were in the private sector, which we're not, the judge...
Well, I want to make it easier for you. How long will it take you to produce Lois Lerner's emails that don't involve 6103 material from January of 2010?
Well,
could we have that by Friday?
Absolutely not.
Why?
No way, because there's no way physically we can get
January of 2010, that's 1 month, no 6103 material, just email.
1 month.
Just 1 month. When can we get that?
We still, well, we have to go through each of those emails to make sure it has no 6103.
Well, how long is that going to take? Can we have it by Friday?
I have no idea.
Just 1 month, Commissioner. Just January of 2010. No 6103, and let me tell you why I'm interested in it.
No, well, I'll tell you, today is Wednesday. I'd be happy to ask the people who do the work and get back to you.
All right, let's do January of 2010, and then let's get ambitious and do February of 2010, and then let's go March 2010. And I think you know why I'm doing 2010, Commissioner. When the President likes 5-4 Supreme Court decisions, he calls that settled law, like the ACA. When he doesn't like 5-4 Supreme Court decisions like Citizens United, he attacks it, which is what he did in January of 2010. And that's why the timeline is so important, Commissioner. The jury is never entitled to know the motive, but they always want to know the motive. You don't ever have to prove why somebody did something, but the jury always wants to know, why did this happen? And if you start in January 2010 with the President's State of the Union address, and then you move through Lois Lerner's emails that have nothing to do with 6103 material, you begin to see a motive develop.
Great. You're going to get 20,000 pages of documents this afternoon. Some of them may well be January 2010. But I will check with our people, because if you would like us to stop that production of Lois Lerner emails and go to January 2010, I will go and find out exactly how long.
What I want is this. I want the subpoena complied with. I want it complied with in a timely fashion. And you and I both know that if there's no 6103 material, whether or not you think we need something or we ought to have it, or that we're on a wild goose chase, frankly, I could care less what you think about that. Our subpoena is our subpoena. If you don't like it, move to quash it. Otherwise, comply with it. Because you noted that our search was overly broad. I want you to tell me what search you would use to find an email where an IRS employee responded, "You who," when she was told that a Democrat won a special election. What search terms would you recommend that we use to find that email?
We've worked from the start of this investigation.
What search terms would you use to find an email where the response was, "You who," when a Democrat won a special election?
We might actually work together to see if there are search terms that would involve political campaigns, elections, political
What
parties.
search term would you use when Lois Lerner responded that a GOP Senate would be worse than a GOP president?
I would actually, if you wanted to, we'd go through and say, look at political parties, look at references to elections, GOP and Democrat.
Or we can do this. Just give us all of the emails she sent or received in January of 2010 that don't involve 6103 material, and we'll decide what we think is relevant and not. Because she said, "I've done nothing wrong, I've broken no IRS rules or regulations, and I have broken no laws." That is pretty broad, Mr. Commissioner.
Now, if I could just have a moment. This is exactly the discussion we've been having for the last year, and we'd be delighted to have, which is, out of the universe, what is it that you think would be most important? We'll give you the universe, but as I say, that'll take you more than this year. If we could figure out.
I just told you, it's January of 2010, because
January
that's when
2010.
that's when the Supreme Court issued its opinion in Citizens United. That's when the President of the United States famously, to their faces in the State of the Union, criticized that, and that's when Lois Lerner began to say, IRS can't fix it, we need a plan, we need to be cautious, we need to make sure it's not per se political. Let's start with January 2010. Can we have that by Friday?
And as I would say, I am delighted, and it's this kind of discussion, for instance, with the
Mr. Costin.
4-year worth of, could I just respond? With the 4 years worth of applications to C4s, we might be able to say, well, which ones would you like, so that we don't spend 3 years at it. January 2010 is a perfectly understandable definition, and we will actually respond to you as quickly as we can.
Commissioner, you need to understand our perspective, though. Maybe this started off as an investigation into the targeting of C4s, but when you have people who are supposed to be apolitical responding the way that she has responded, Tea Party dangerous, maybe the FEC will save the day, we got to make sure it's not per se political. When you have people in positions of authority and responsibility that are expressing overtly political commentary on government email, I think we ought to be entitled to all of them, and that's why we asked for it.
Chairman. I would just simply note that, for the record, that you already have all those emails, which is why you have all of that information. So it is not.
We don't know what we don't know, Mr. Commissioner. We know the ones we have.
You know the ones we have, and
I got it.
We'll go to January 2000.
Mr. Costin, here's the point. There are 2,400 employees in the Chief Counsel's office of the IRS. A bunch of those people are lawyers. This is so important. Mr. Lynch said this, not Republicans. Mr. Lynch said this is about First Amendment free speech rights, political speech rights. This is so important. What Mr. Gowdy is saying, what we've all been saying is, take some of those lawyers, that 2,400, a bunch of them are lawyers. Take some of those lawyers, get every single email that Lois Lerner sent, start with January 2010, go through those as quickly as possible, and get them to this committee. And it's not just Republicans who want that. Mr. Lynch has said he wants that. Mr. Cummings, the ranking member, said he wants that. Make it a priority. We asked a year ago. We asked in May of 2013, get us Lois Lerner's emails. Then we subpoenaed them, and you're still telling us it's going to take forever, we can't do it. You're giving us, we don't want the excuses anymore. Prioritize it.
Right.
Put more lawyers on the job. Of those 2,400 in the Chief Counsel's office, assign someone to do exactly what Mr. Gowdy's asked for.
This has been a priority. That's how we've selected and produced.
Hey. When we're talking about the First Amendment, you're not working fast enough. It's that simple. You're not working. This is fundamental. Mr. Lynch said it. Mr. Cummings has said it. We've all said it. Get on the job. Put some more lawyers on this.
We're on our job. We have 89,000 employees having nothing to do with this, doing very important work for the government. We have 10,000 fewer employees than we had 4 years ago. So it's not a question of just pushing a magic switch.
Mr. Chairman, I just need 1 minute.
Gentleman's recognized for 1
We
minute.
can, wait, just, please.
Or you may.
Yeah, no, I just need a minute.
I got it.
Okay. You know, the gentleman, the commissioner, has said he's willing to produce the documents. We've got almost every member now asking for documents. One of the things that I'm saying is that we need to be very clear at the end of this hearing that we do what you apparently have done with Mr. Camp, Chairman Camp, and others, to make sure that we are all clear on what we want, because different people are saying different things. And then listen to me, or we'll end up right back where we are right now. So we need clarity. The chairman wants certain things, Gowdy wants certain things, I want certain things. And so some kind of way we need to come make sure we have a meeting of the minds of exactly what we are trying to get. And that's all I'm saying, Mr. Chairman. I mean, that's reasonable. And I think one of the things, mistakes that we're making, we're beating up on him, and he's clearly trying to cooperate and trying to give us what we want. But again, he's got his own restrictions. So I want to make sure that that he's saying he was willing to give us what we want. We've now got to be clear on what we want. That's all.
I would just say to the ranking member, I think we have been.
Well, he apparently
No. All means all. All means all. Because if we let any type of restriction happen, any type of parameters be set, then they're determining what we get, and the American people aren't going to be able to see everything. That's why we
now do you now so therefore and this is hopefully this will be helpful. So now do you understand that? And I see that the chairman of the full committee, I guess he is in agreement with what was just said. Do you understand that? What we want?
What they want is something that's going to take years to produce, not just the emails. What they want is documents. And again, our point is not that we're not going to give it. We're just telling you it's not going to happen overnight. We've tried to prioritize. First, you got 690,000 documents in Ways and Means. Try to prioritize. That's the lowest learner emails. We said we'd provide them. We said the first priority is we'll get them that say this. We have to redact them. We've given them to Ways and Means. To the extent I said it was very helpful, if you say, the months that we're really interested in are these, those, and those, we can prioritize those. It doesn't mean we won't give you the rest of the months, but this doesn't happen overnight. It's not a question of showing up with another 150 people who become 6103 experts overnight. We've got a team. Yeah, we aren't a document production team, but an organization. We've created one.
If the gentleman would yield, for the foreseeable future, there is only one person you have to work with on priorities, and that will be the people working for the committee, and I'll work with them.
Good.
When Mr. Gowdy said he's very interested in January, so am I. I want to attach my comments to the ranking member here to the greatest extent possible. We do not want to be overly burdensome. We do, Mr. Lynch and others, think that certain individuals, we want all of their emails. I would note for the record that of your 6 investigations, there's only 2 that you have to do 6103 for. You don't do 6103 for the TIGTA, you don't do 6103s for Senate Finance or Ways and Means, and I'm assuming the Justice Department has a way to fast-track getting what they want. So of the 2 entities, us and our counterpart in the Senate, one of the challenges is we have watched Ways and Means negotiate to get less than all of Lois Lerner's emails when, in fact, 6 months ago, you could have pumped out all of Lois Lerner's emails and dumped them in one fell swoop on Senate Finance and Ways and Means. You did not do that. They eventually negotiated, to my consternation, a subset of all of her emails. I find it less than helpful. And I find you're talking about redaction and time inappropriate when you could have given Ways and Means all Lois Lerner's emails in a matter of seconds. It really is that simple. You've already gathered them, and I assume that TIGTA has access to them. So I appreciate that we will have to work with you to prioritize, and we will, and we always have. In the case of any parts of the document production in which there are massive numbers of potential documents, we will particularly prioritize. For today, for the record, on behalf of people on both sides that have spoken, Lois Lerner's emails, all of Lois Lerner's emails, is the highest current priority of this committee, and it will remain so as long as I'm chairman. So I'm not going to get into January, because I believe that if your team had been actively working in a matter of days, you would have been able to give us substantially all of Lois Lerner's emails, and within a matter of a couple of weeks have given us the ones that required 6103 redaction. And I know this based on how long it took my people to hand read the emails we got.
Right. I would just say that that's not the information I have.
Gentlelady from New Mexico is recognized.
Thank you, Mr. Chairman, and I'm going to take something the chairman said, and I hope he doesn't mind, and use it out of context. So all means all. I'm going to go back to none means none. And I want to talk about the exclusivity requirements of 501c4s and the fact that we don't do that. And I'm going to do what other members have done and take you, I hope you'll take me back through these baselines again. So, Commissioner, your agency administers how 501c3s or charities are treated under the tax code, correct?
Correct.
And under federal statute, charities cannot engage in any political activity, correct?
That's correct.
How much did charities spend on partisan political campaign activities in the last presidential election?
I assume none.
I hope that's true. I'm assuming that it's $0 as well. Now, you also administer social welfare organizations, 501c4s.
Correct.
And under federal statute, laws that Congress passes, we get very excited when the administration and others don't follow the laws and the rules that Congress passes. We said, Congress, that social welfare organizations must operate exclusively for the promotion of social welfare, correct?
Correct.
Next page. All right, and political campaign activities are not a C4 social welfare, not part of their mission, correct?
Campaign activities with regard to supporting individual candidates are not social welfare activities.
Exactly what I mean. I understand that they can do advocacy, and I might even ask that again as we're creating our baseline. How much did social welfare organizations spend on political candidate campaign activities in 2012?
Quite a bit. I have no idea what the final number is.
Well, let me tell you that it's pretty close to $250 million. $250 million on political campaign activities in 2012. Do social welfare organizations have to disclose their donors behind this $250 million?
No.
So social welfare organizations must exclusively promote social welfare under federal law, but instead they're spending hundreds of millions of dollars on political campaign activity while keeping their donors secret.
Correct.
Social welfare organizations are blatantly violating federal law. Doesn't make sense to me, and I don't think it makes sense to most of the people who are here. What will it take for the IRS to enforce federal statute for social welfare organizations, just as you have successfully done for charities, so that social welfare organizations are exclusively promoting social welfare agendas and not their partisan political agendas? Does it take another act of Congress?
Well, at a minimum, it would take a new set of regulations under 501c4 because, as you know, the present regulations adopted in 1959 provide that a social welfare organization only has to be primarily involved in social welfare activities.
And I have to tell you, I don't understand that, because the law is clear. We have a reg that's, in my mind, is completely in violation, and I'm a little worried, although I've got a bill that proposes to do just that, require the IRS to follow the federal law and not make decisions after the fact, subsequent to that, that are some interpretation that, I've got a dictionary, exclusive means exclusive, none means none. I need to know that another act of Congress would actually be taken seriously and be followed exactly as the law says. If we pass another law, will the IRS follow that law?
We will follow that law, although the IRS and the Treasury Department always issue regulations for interpreting and applying the law in a way that seems to be most effective.
And I certainly don't want to push you into, you didn't, I think, come up with this regulation on your own, but in fact, I don't understand how any regulation could be interpreted to allow up to 49% when the law says you must do exclusively social welfare. Because my bill clarifies that that's what we should do, because I want to ensure that political money is disclosed in the way that it's supposed to be. I can't believe really that we're here, but I'm encouraging the IRS, because I don't think that we should be doing the regulatory work, because I think exclusively means exclusively. But given the reality that we are there, that this did occur, I encourage you to implement a regulation that complies with the federal statute, ensures that the social welfare groups do not engage in political activities, instead of continuing to debate how you would go about identifying what constitutes political activity, and to continue on a debate like this about what might have gone wrong if it went wrong. I would suggest that you go back to what the law said you must do, and go back to exclusive and not allow social welfare organizations to engage in any partisan campaign activities.
Well, as I noted, the draft regulation asks for public comment on 3 issues. One is, what is the definition of political activity? 2, how much of it should you be allowed to do without jeopardizing your tax exemption? And 3, to what organization should it apply? So we've got comments, and we'll have a public hearing, and the issue about how much is appropriate will be available for comment, and any final regulation will have to deal with that.
Thank you very much, and I realize I'm out of time. I disagree that there still ought to be any effort not to hold them accountable based on what the federal law says. And with that, Mr. Chairman, I yield back.
Gentleman from Arizona is recognized.
Mr. Commissioner, I'm a dentist. I'm not an attorney. And so I want to talk about leadership and how we do things efficiently. So I have a patient, and when they come in, I want to make a diagnosis. So I kind of want to know the storyline. True?
I'm sorry, you want to do what?
I want to do a diagnosis. I got a problem. I want to do a storyline. I want to figure out what the story is, right? In your world, it's called discovery.
Yeah, we actually would, want to do, if you have, you're interested in finding out what a problem is, you would actually go find what the
And
facts
so it makes sense that you would create this storyline from where it started and move it back, don't you think? I mean, along my lines, my colleague over here, Mr. Gowdy, asked.
Well, I'm not quite sure. If I were doing an investigation, I would actually want to know what the facts were before I developed the storyline.
Well, you base the facts off of the inquiry about documents, like all of this stuff that has all these redacted comments. But you want to start at the beginning of the storyline. You don't want to start in the middle. I mean, most authors will start at the beginning of an instance and move forward, right? And it takes leadership to direct troops or direct people within the IRS to do so, wouldn't you think?
Certainly takes leadership to direct the employees.
And I guess that's my point is that, you know, if I'm doing my job, I want to create a storyline to facilitate this oversight committee. True? Make it easy.
I'm not sure what you mean by a storyline.
Well, you want to make sure that you're presenting this to us in a rational manner that allows us to do our job.
Yes, I have made it clear to our employees, A, that a priority is to cooperate with, with the 6 investigations, get the documents as quickly as we can to them, and to the extent that they're voluminous, try to figure out with them what the priority is in terms of providing them.
And I want to catch you right there, because it's the comments I keep hearing here. It's the storyline. I can tell all my employees, okay, I need an X-ray of this, 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 and this, and they can just go off on tangents. And it's not efficient in giving us the documentation in which we want to learn. True?
Again, if we give you heaps of documents.
But once again, I'm going back to a storyline, because it seems like.
I'm not sure where the storyline
the storyline starts at the beginning of the story, right? You want to go back. Mr. Gowdy asked, don't you think it's important that we start in January? Doesn't that make sense? I mean, you rationally put this together, and you want to have oversight from this committee, so you rationally want to put this storyline together in a rational manner. I mean, you can do all you want. I mean, throw stuff at us, and it's going to take us a lot of time. But it seems like more efficiently, from director of your position, that you would direct employees to say, let's start at the beginning, what we think is the beginning. We're going to start giving you all these information starting in January of 2010.
No, we didn't do that, and we wouldn't do that. We actually sat down with the committees and their staffs and said, what would you like, what documents do you want, how should we search them, what issues are you looking for, and we took the storyline from you all.
And you took it from Oversight that when we said we want lowest learners, all of our emails, the comment from you would have been then, if I'm logistically thinking as somebody that's choreographing this story, do you want me to start in January? Where would you like me to start?
For the lowest learner emails, as I said, with lowest The idea is if January is a good place to start, that's fine. Ultimately, as I said, we've provided already, and you'll get more this afternoon.
You're running around and around and around. I'm from the private sector, and this makes no sense.
I spent 20 years in the private sector.
Well, then you should know better. That you should know better in producing a storyline that makes sense, to say, listen, you're here to serve, right? Because I'm here to serve. How do I make this easier for you to have oversight? So I'm going to stop there, and let's go to something here.
All right.
And since Lois Lerner didn't comply with our questions, we need all those emails. And I want to make sure you're willing to provide them, like we said, all of them.
Correct.
Okay? And would you be interested in choreographing them, start, finish, kind of in bulk?
Yes, we already have a search going on for examinations, appeals, and the regulatory process, because that was determined to be the storyline that would be most helpful. We've added now, the next thing we're going to do is January of 2010, and in fact, if we can do that first, because if it were easy, I'd be happy to comply with that request. But the storyline is, thus far, of her emails, which will take us weeks still to redact, the suggestion and request was, and we try to deal with all investigators the same way, start with exams, appeal, and
I got you. I got one more question to ask you. Is it true the IRS has given the same documents to the White House and to Congress that had different redactions? Is my understanding that may have occurred?
I have no understanding that we've redacted differently for anybody. There are
would
those who have no redactions, and those who get redactions get 6103 redactions, and their redactions for 6103 apply to everybody.
I would want to make sure that that's followed up and
That's fine. If you have other information, again, we'd be delighted to know it.
Thank you.
Mr. Costin, if I could real quickly, while Ms. Holmes-Norton is talking with the chairman, prior to being nominated, did anyone from the White House approach you, ask you, talk to you about the proposed C4 rule?
No.
Did anyone in the course of the, before you were officially nominated, anyone from the administration talk to you about the proposed C4 rule?
No.
And did you, do you view, I'm just curious in your mindset, do you view your role as Commissioner of the Internal Revenue Service, do you view that as a independent role, or are you part of Treasury and part of the administration? How do you view your role as head of the Commissioner of the IRS?
The IRS is a division of Bureau of the Department of Treasury, but it runs and it's independent as far as tax administration. And as I said, I view it as a critical issue. Randall Thrower died recently, who set a standard that the IRS should be independent.
You view the IRS as an independent agency, even though it's housed within Treasury.
And not a political agency at all.
And when you prepared your testimony, did you and the people at the IRS prepare that, or did someone from the administration or the Treasury help you prepare that testimony?
Testimony for today?
It's testimony you submitted.
I prepared it.
Came from you and the IRS.
Right.
If I could, real quickly, I want to put up a couple slides here. I want to start with slide 1. This is a letter that Chairman Dave Camp received 1 month ago from, pardon?
Thanks, I appreciate that.
Okay, okay. Okay, I'll wait. I'll go with them. Ms. Norton was talking with the chairman, and I thought I would use the time, Mr. Ranking Member, to get some important information.
We get equal time?
I'd be happy to. If you let me go, I'll be happy to give additional time.
I would just like to go because I've got something at 12 o'clock if I could.
Gentlelady is recognized.
Thank you. And I wanted to come because John Koskinen is a good, and should I say an old friend, because we were in law school together. And it turns out to be the man, if there's a job in the government that can't be done, they call on John Koskinen. So I thought this is one of those jobs. I do want to say...
Eleanor started law school as a very young person. I was older.
I do want to say that the committee's obsession with Lois Lerner, I think, could have been avoided. The committee asked her earlier, asked her attorney, would he be willing to engage in a proffer? Proffer would have said what she would have testified. And then I think all of that, a lot of what's in those emails would have come out in an attorney's proffer. If the point is to find out the truth, it seems to me at least we could have gotten through a lot of that here. But I do want to clear up something about these so-called lists, and I looked at what the IG had found, and I'm intrigued, and I think the record needs to show this. And it's clear that the IG found that they had used inappropriate lists for these so-called BOLO lists, this be on the lookout lists. But he also found, is it not true, that higher level management was not involved. Apparently IRS people do these kinds of things all the time. they did not know. Only first-line management knew about the references that trouble us to Tea Party, and so this just stayed in place. Is that not the case?
That was the IG's report, yes.
Then the IG later found that Lois Lerner, who has been the obsessive subject of these hearings, didn't even learn about these inappropriate criteria until a year later. And then she immediately ordered the BALO list to be eliminated. And again, and isn't this interesting, for lack of proper, I think, oversight, perhaps, these workers just went back to it because they couldn't figure out a way to deal with the issue that has been discussed earlier in these hearings, which is how do you know which are primarily and which are not. And so they went back to the list, and when the IRS learned that their subordinates were again using this criteria, they then said you'll have to have executive approval. Well, what impressed me was that your predecessor has gone beyond the notion of getting executive approval, and he said the use there is to be no more use of these beyond the lookout list, this BALO list. Is it correct, Commissioner, that the IRS no longer uses these beyond the lookout lists for anybody at any time?
That's correct.
And so they've gone further. The IRS has gone further than the IG asked to go. As I understand it, the IRS has now complied with, or is in the process of complying with, all of the recommendations of the IG. Is that correct?
That's correct.
I must tell you, John Costin, and if we want to find out any more, I think what I do, rather than trouble you to go through thousands more emails, is to take the agreement, apparently, of Lois Lerner's attorney to offer a proffer so that we could find out what she would have testified, and then we may get closer to the truth and eliminate some of the need for some of the emails. Thank you very much for coming forward, and thank you for agreeing to do this job.
Mr. Collins. Thank you, Mr. Chairman. A lot's been said about emails when you produce them, and we're going to talk about that in a minute. But I think one of the issues that really hits at the heart here of people not understanding when it is portrayed and it is put out that the IRS has done something that was wrong, that was misguided, the terms that I've heard you use today. This is what has drawn the parallel of looking at government and not trusting it, and it heightened it even more. So that the fact that if we started off with a bad taste, now we're getting worse, and then when it seems like we are obfuscating and we're keeping back and we're hiding behind requests and defining all and every, and what are these definitions? People don't get that. And to come to this committee for either one of us and to say simply, well, we're going through and we're working that out, people don't get that. They're tired, and both sides. This is not, this actually is from a hearing we just had just a few weeks ago. Groups on the left and the right are tired. They don't get this, and they don't understand why the IRS acted this way. But I do have some questions that I want to say. You officially took over when?
I started on December 23rd.
So you started December 23rd. Are you familiar on the date that the first subpoena was issued to the previous commissioner?
The first what?
The first subpoena for documents for these?
No, the first subpoena actually went to the Secretary of the Treasury.
And it was on, do you know what date that was?
That was in August.
Yes, it was. You came in December. You were issued a subpoena on February 14th, correct?
Correct.
At what stage did you find what we'll just say is the compliance to the first subpoena when you took over in December?
I was not familiar with and wasn't focused on the first subpoena. It went to the Treasury Department.
Okay. When it was being worked on in the IRS to get to when you get the subpoena on February 14th, are you saying then that basically we just started over to answer the subpoena that you got?
No, actually, it turns out we had already provided and have provided significant information on all of the categories of the subpoena.
Significant. Okay, but the February subpoena asked for what?
February subpoena asked for all emails, all documents related to
Okay.
501c4.
Would that be, does significant mean all?
No, we actually
Okay.
have not provided all. We've provided just a amount.
I think-
And we've said we're going to continue to work with the committee to provide other documents.
And this is where it gets to the point of understanding, especially because this has not been discussed in the last 3 months. It's not been discussed since December. This has been going on for coming up only a year now.
Right.
That it has been discussed and understood and has been talked about, and especially as it got targeted around several individuals, Lois Lerner being one of them, that there seems to be, this is, and I think what previous was taught about a storyline, or however you want to put it, it's not a storyline, it's the fact that there are information wanted, there's been information requested, and that you made a statement earlier and you said that the public needs to feel satisfied about what's going on. Do you feel they are satisfied right now?
I think the public will be very satisfied when this committee issues its report.
Okay. But one of the issues that they are right now is that they're being satisfied, is they feel like that they're not getting, wouldn't it be, you said you want to get this as soon as possible. I agree with what I believe the chairman said earlier and others. Make this a priority. Get this off the table. Wouldn't it seem to me that if you want to provide all, and you said, and I take you at your word, that you want to provide all, that this would be something that you would go ahead and get off the table as quickly as possible. And I'm not sure we buy the fact that it's going to take this in redaction, because you've already said most of it might not even need redacting.
No, I did not say that. Others have said that.
Okay, so you're saying that every one of them's going to need redacting?
No, everyone's got to be reviewed to see whether it has to be redacted.
Okay,
we cannot give you any taxpayer information, and every document, every page
And nobody is
has
asking
to be
you to do that.
reviewed.
But when you get, I think the problem here is this. You've walked into a position in which the trust level is 0. And now for this committee has asked for all documents, and it's not a matter of what we're going to redact, it's just get all. And we were asking, you said we need to do that, but the people don't trust us anymore. With my last minute, though, I do have, I will yield to the gentleman from Ohio. He had a question. We need to get this off the table. Gentleman from Ohio.
I thank the gentleman for yielding, but frankly, I don't know if I have enough time to get through the material I wanted to with the commissioner, so would yield back to the gentleman from Georgia.
Right. With that, Mr. Commissioner, I take you at your word, but the people that I go home, if you, we don't talk about hardly anything else when I go home, except IRS, Benghazi, these other issues that the people feel like they're not getting an answer on. And they're tired of these kind of hearings in which we say, well, we're getting to it, we're coming around to it, and especially when they're asked for it, they're demanded the answers from the IRS or others when they're asked for it on a different timeline. It's time to get this done.
Would the gentleman yield?
The gentleman will always yield.
I just want to make it clear of one thing. You know, every time you go back and talk about $6 million of new computer equipment and the time it takes to redact, I'm reminded that Ways and Means is only a week ago was still negotiating to try to get subsets of information when, in fact, there was no redaction necessary. You could just do a computer dump on them. So very clearly, you did not use that $6 million of new equipment to grab all the emails and just send them over, but in fact, your agency and Treasury was slow-rolling Ways and Means and Senate Finance exactly the same way as you're slow-rolling us, but without the excuse for redacting.
I think is an improper characterization. We, with Ways and Means, have been working through the priorities, trying to figure out how we can get them the most important, significant information that they think is significant as quickly as we can. It is going to take time. It has taken time. There's no higher priority in this agency than providing the documentation. But oversimplifying how easy it is doesn't help us very much. It won't make it go any faster. We are committed to continuing to cooperate. I said earlier, to the extent we can work with you and identify within the broad range of the subpoena what you would like first, we're happy to do it. Doesn't mean we won't give you other stuff later. With Ways and Means, we've never said that's all you're ever going to get. With Ways and Means, we've worked with their staff very productively to say, here's where we are, what else would be helpful to you, what else do you need, and we've been providing.
Very productively for over a year, and they still don't have it all. That says a lot when there's no redaction required. Mr. Meadows.
Thank you, Mr. Chairman. Commissioner, I want to go to that time frame. If you have someone where the IRS is requiring documents from an individual, audit or whatever, is it an excusable excuse to say that they don't have the time and it's going to take a year or two to get you the information? Is that a permissible excuse to not give the IRS documentation?
In the course of examinations, we have audits of large corporations, and it takes us years.
But me as an individual, let's say if I came to you and just said, you know, golly, Commissioner, it's going to take a long time to get it. At what point does the IRS say that that's not okay?
We'd say that after we understood what your circumstances were. If there was a legitimate reason it was going to take time, we'd take time. There's no way we would ask you to do something you couldn't do.
All right, so you're saying that it's going to take years to get us this information, according to your testimony a few times ago.
With regard to all of the documentation about all of the applications for 4 years, my understanding is it's going to take years.
But we're talking about Lois Lerner, all of her emails. How long would that take?
I cannot tell you. All I can tell you is the redacted version of
So let me ask you this. Let me change. Let me ask this. At what point should this committee hold you and your agency in contempt for not complying? I mean, what's the timeline?
Well, I think the timeline is whenever you think you could actually sustain that in a court. I think we have a strong case that we have been cooperative, continue to be cooperative, and anybody looking at the systems we have and the time it takes would find that we've provided you more cooperation than, in fact, might be expected. And I think that, in fact, arguing and threatening contempt in that situation without understanding the circumstances is probably not going to be held up.
Well, I appreciate your opinion. I can tell you the people that I represent, they believe that you're stonewalling. And this testimony today is an indication, because you've gone over and over again of trying not to answer the questions that many of my colleagues have answered. You've qualified those. But let me go on to another point. February 3rd, you made an announcement that you were going to reinstate bonuses to the tune of $62.5 million and give those back and go against the decision that was made on July 29th. On March 5th, Secretary Lew, I guess testifying before the Senate Finance Committee, said that quote, the senior managers who were anywhere in the chain of command who exercised bad judgment in the running of the program are no longer there, implying that they would not get a bonus. Would you agree that they didn't get a bonus? Anybody who could have been involved in this targeting did not get a bonus.
Yeah, those people aren't in the pool. This is not a bonus pool. It's a performance award pool that goes to bargaining unit employees.
So anybody involved in the targeting, my question, let me make it specific. Anybody who was involved in the targeting did not get a bonus. Is that correct?
First of all,
yes or no? Yes or no?
I have never said there was targeting, so if you'd let me clarify what the answer is, I'd be nobody.
So today you're saying that there was not targeting?
I am saying the IG found that
I'm saying, what did you say? You're the one here testifying.
I have said that this committee and 5 other investigations will tell us what the facts are. I have made no judgment about what happened because I've made no investigation.
So anybody who might have been in what I would call targeting, did they get a bonus? Do you know?
And they would not have been eligible unless they were in a bargaining unit. I don't know who's in the bargaining unit and who would have gotten those.
So somebody that was involved in this could have gotten a bonus?
There are frontline employees in the exempt organization.
What about senior level management employees? Those bonuses come out to the tune of $10,000, $20,000 per employee. Did anybody that potentially could have been involved in these decisions, in the bad management practices, could they have gotten a bonus?
Not to my knowledge. None of them, in fact, are there.
All right. So let me ask you, how do you make that definitive of a statement if the investigation is not done? Because we don't know who's actually involved unless you're making an assumption of guilt or innocence. So how would you know that?
I would know that because you've given us a list of everybody you think's involved. We've actually gone through the production of documents. So if there's somebody who's been involved that isn't on any of those lists and hasn't shown up.
So your testimony here today is everybody that we've identified is innocent. That's your testimony.
I know. You asked whether they got bonuses. I said nobody who's not there got a bonus. Whether they're innocent or not, I don't know. I'm waiting for the results of the investigations.
Okay, so you can't assure us that they didn't get bonuses because you don't know who they are.
If I can clarify the gentleman's answer, I believe, and correct me if I'm wrong, if we have identified individuals as people of our specific inquiry, those names, I think the Commissioner is saying he knows they did not get bonuses. Is that correct?
That's correct.
Okay. And obviously, there may be others involved, but if we haven't identified them, I can see the Commissioner's point.
I thank the Chairman. I yield back.
Thank you. The gentleman from Michigan.
Thank you, Mr. Chairman. I've been here all day or all morning listening to you and the questions being asked. And somehow I feel like I should have came in here with boots on because we're mucking out a chicken coop. That's what it feels like. Trying to get to the truth, the hardest thing to find in Washington. I've heard you say you made no investigation. You've been here 4 months, correct? Or working for the IRS for 4 months. Made no investigation, yet you said we have 6 investigations going. It's a serious issue. I think that should have been the first thing on your list. I've heard the opposing side say, we're spending a lot of money on this investigation. Why? And I can't help but think my brothers and sisters in uniform fought for this country on the beaches and the jungles and deserts, defending the freedoms guaranteed by the Constitution, and the IRS just takes that with, well, must not be very important to them. And that's insulting to me. It really is. Freedom of speech is very dear to my heart, as is the rest of the Constitution. I fought in 2 wars for it. I don't care how much it costs to guarantee those freedoms. And I'd like to thank the chairman and the committee for spending so much time and energy on this. But I'm going to cut through everything. Because I don't really believe you when you say it's going to take 20,000 pages and it's going to take years to get emails.
I didn't say it about emails. I said it would take years if you want all of the C4 applications for 4 years and all of the documents related to it.
Okay, we're just talking about emails.
If you're talking about emails, I never said it would take years.
Okay, you know what? I know students in my high school class that could probably go in there for you and get them done in the morning.
I'll bet they couldn't make 6103 determinations.
No, that's right, and that's not what we're looking for. What I'm looking for is the emails from Lois Lerner.
Emails from Lois Lerner, every page have to be looked at to make sure there's no 6103 information on them.
Maybe we should just get those from the other committee where you didn't have to do that.
That's
and
right.
they could do that. And you can just provide them to them, we can get them from them and redacted. But anyway, I have some really quick questions. In 4 months, you haven't done any investigation, but I know that you've talked to people in your office, you've asked them some tough questions that you're not coming forth with us today.
That's not true.
Not true. Well, let me ask you, in your opinion, were conservative groups targeted by the IRS to stifle opposing views prior to the presidential election?
All I know is what the IG found, and he found that appropriate.
What do you know?
Pardon?
Yes or no? Do you believe, in your opinion, do you believe the IRS has done
I have
that?
not taken an opinion on this. My position is.
It's an easy way out. Thank you. Did Lois Lerner plan, organize, or targeting conservative groups in cooperation with, at the suggestion of, or at the direction of members of the Senate or White House staff?
I have no information about that. I'm waiting.
You've been there 4 months. You said it was a serious issue, and there's 6 investigations. You would think you would ask your people directly those questions.
No, what I've asked my people directly is, have we implemented and accepted the IG's recommendation to solve whatever management problems were in the system to make sure that whatever happened never happens again? That's what I think my job is to take the organization, manage it going forward. My job is not to look backwards in time. My job is to try to make sure that we can assure the American public that whoever deals with the IRS, no matter what their political background, their affiliations, what church they go to, who they voted for, are going to be treated fairly. That's what I think my responsibility is. That's what I think I have an obligation to the American taxpayers to do.
Thank you, Mr. Chairman. Yes, I'd like to yield to the gentleman from Ohio.
I appreciate the gentleman yielding. If we could go back to where we were just a few minutes ago, Mr. Commissioner, you had indicated that you view your role as independent from anyone in the White House, the Treasury, even though you're housed in Treasury. You'd indicated that your testimony you prepared, you put together, and you submitted and read from some of that today when we started the hearing. I want to just point out a couple things that I find interesting. Let's go to slide 1 if we could. This is a letter from Alistair Fitzpaine, Assistant Secretary of the Treasury, to Dave Camp from 1 month ago. And then we have your testimony from today, March 26th, a month later. Second slide there, your testimony, seven or 8 pages, I think, in your testimony. And then I want to go to page 7 of your testimony. Next slide, if we could. Now, this is what I find interesting. This is your testimony side by side from a paragraph that the Treasury wrote to Chairman Camp. And this is language is even closer than earlier when I asked you about the proposed questions and the inappropriate questions and the similarity there. This is basically word for word. Take the first one. There have been numerous misleading reports in public state regarding proposed regulations. Exact same language from yours. Then you talked about the first draft regulation does not restrict any form of political speech. Mr. Alastair's Fitzpain's letter, exact same language. Second, exact same language. And we'll give you a copy of this. Go to the next slide if we could. Draft regulation. This is all, again, talking about the C4 rule, the draft regulation.
You're going to have to wrap up.
Okay, draft regulation. What I want to know is, if you're independent, if you put together your own testimony, why does it read word for word exactly what the Treasury sent to Chairman Camp? I mean, it seems to me either it's plagiarism or it contradicts what you told me earlier, that you prepared your own testimony and that you're an independent agency.
The gentleman's time has expired.
Treasury wrote your testimony.
Respond?
Yeah, please.
I'll respond on my time. I wrote this testimony. I read Mr. Fitzpain's letter to Chairman Camp. I did not have any role in drafting it. I thought the points he raised were good points, and I thought it was important to put them in my testimony. That, in fact, it is important for people to understand that these draft regulations are open to public comment. I have an open mind about them, but it's important for people to understand that people can engage in political activity any way they would like. They could become a 527 and do nothing in an organization but engage in political activity. Whatever regulation we come up with is not going to be focused on and should not be focused on keeping people from doing whatever they want elsewhere. It's focused on what should 501c 3, 4, 5, 6, and 7s be able to do or not able to do. And I thought it was Mr. Fitzpain's letter to the chairman seemed to me accurately portrayed the situation, and I thought that therefore.
So you lifted the language inserted in the letter?
I apologize, but we're going to go to the gentleman from Florida, Mr. DeSantis.
Thank you, Mr. Chairman. So, Commissioner, if you right now had a stack on the table there of every email to, from, or that copied Lois Lerner, and all the 6103 information was redacted, would you have any problem just delivering all those emails to us immediately?
No, if I could get them on a stack on the table.
So it's basically about the process and the burden of getting the emails. You don't have a substantive objection to the fact that we want this information?
No.
Okay. So do you know how long it would take to just pull those emails that I mentioned? Don't do the 6103. Just get the emails, most likely in electronic form. Do you have any idea how long just that first step would take?
I do not.
Can you find out and report back to us?
I would be delighted.
My understanding is that that part would not take very long. So you have no idea, as you sit here, how many of these emails involving Lois Lerner even exist, correct?
I have no idea. That's right.
So you can't say that going through the documents for 6103 information would necessarily be burdensome, because we just don't know how many emails we're talking about, correct?
That's correct. All I know is the burden of just trying to get you the redacted versions of her emails about exams, appeals, and the regulatory process is going to take several weeks.
No, I understand, but I mean, for example, we don't know. There may be 50 emails of her cheerleading Democrats, criticizing Republicans. There could be 500 of those. There could be, so we don't know. So I think you understand the committee views Lerner's emails as the highest priority. I think if you could figure out for us how long it would take just to pull them, and then once that is done, let us know how many we're talking about, because what we don't want is to just see this being dragged on, and that may not be your intent, but a lot of my constituents don't believe that the IRS has been forthright, and I think that that's bad going forward generally. There's another issue that I get asked about a lot by my constituents, and you were not the commissioner, so this is not on you, obviously, but Lois Lerner testified last May. She basically said she didn't do anything wrong, then she took the Fifth Amendment. Now, obviously, we think that she waived it. Some people don't. Put that aside. Just as an IRS commissioner, if you have somebody that high-ranking that comes and they're being asked questions about their official conduct in office, what do you do if somebody invokes the Fifth Amendment? Now, we know that protects them against criminal prosecution, self-incrimination, but just running your organization, what then happens to an employee going forward if someone is in that situation where they cannot discuss what they did in this official capacity?
Well, as you know, she doesn't work for the IRS anymore. If an employee takes the fifth,
Well, she did at the time, though, and I know you weren't there, but I'm just asking you, how do you analyze that situation? Because we had another IRS official take the fifth involving some fraudulent conduct, and not related to this investigation, and it just seems like when that happens, it's kind of like, okay, we'll reassign somebody and kind of go on your day, but a lot of my constituents look at that, and they lose confidence in that official's ability to conduct their duties.
Right. And as you know, the assertion of the Fifth Amendment is not meant in any way to cast doubt on the guilt or innocence of the party or what they would say. And so what we would do in any normal circumstance like that is consult with our personnel people and our legal people to see what the circumstances are and what authority we have to take whatever action we do. But if we actually, anytime anybody exercised their constitutional rights, if that was grounds for dismissal, it clearly would undercut the vitality of those rights. So I don't think you can automatically say everybody, whoever asserts the Fifth Amendment on any issue would automatically have adverse personnel actions, but we would immediately take a look at it.
And so you think, though, that it could cause you to reevaluate that individual's position and whether they can conduct their duties? Because I just think that, this is the public's business. If we can't get answers to some of these questions, put aside what happens to them criminally. I'm not talking about that. I'm just talking about the transparency that I think the taxpayers deserve, especially given the power of your institution, that if you do have people who are misbehaving and targeting citizens, there's a few organizations where that's more detrimental to freedom than the Internal Revenue Service. And so I appreciate your diligence on getting us the answer on Lois Lerner's emails, and I'd yield back the balance of my time.
I thank the gentleman. We now go to the Dean of the Wyoming House Delegation, Ms. Loomis.
Thank you, Mr. Chairman. Mr. Koskinen, welcome to the committee. Thank you for being here.
It's been a wonderful day.
I'm sure. I'd like to ask you if you ever met Lois Lerner, Holly Paz, William Wilkins, or Jonathan Davis.
The only person I've met is William Wilkins, who is still the general counsel of the agency.
Have you ever spoken to him about tax-exempt organizations?
Tax-exempt organizations. I have not talked to him about specific ones. He's been on meetings where we've talked about issues such as responding to the IG's recommendations.
Have you ever talked to him about Lois Lerner?
No.
Have you ever talked to him about Holly Paz?
No.
Have you ever talked to him about Jonathan Davis?
No. I should say, never talked to him about any of those people in terms of who they are and what they did. He has been in meetings where we've discussed trying to comply with the request for discovery, and those names have been mentioned, but I've never talked to him about any of those people individually or their role at the agency.
Do I understand correctly that you are willing to respond to item 1 in the subpoena prior to responding to items 2 through 8 in the subpoena?
Now, item 1 is Lois Lerner's emails?
It is.
Yes. Now, as I've said, we understand we're going to start with January. We're going to continue because we've already started that process. I think it's important to get you all of the emails in the areas that I talked about, and then we're going to find out about January, and we'll continue to work with you as to what order and priority, and we'll let, as noted over there, let you know how many emails there are and what the process would be. We're delighted to do that.
Thank you. Are you aware that there's a deficit of trust on the part of the American people with the IRS?
I do not know that personally. I've heard from a number of people talking about their constituents being concerned, and I assume and I believe those are accurate representations. Whether they represent the entire public or not, to me, is not important. I think every individual member and every organization in the country deserves to feel comfortable that they're going to be treated fairly by the IRS. So my view is, whether it's the entire country or only segments or parts of it, is not the question. It is important that everyone feel confident and comfortable dealing with the IRS.
And indeed, when I go home, as other members have stated, including Mr. Lynch, what I hear is there is a deficit of trust, that people feel that they're being targeted not only from the tax-exempt organizations, but from other entities within the IRS. I have a constituent who has been involved in an estate matter for years since her husband died, who has the IRS coming and asking what brand of bedroom furniture she has. That is, and she has paid $50,000 to accountants to try to address the questions of the IRS. That seems to me, by the way, she just happens to be a national committee woman for the Republican National Committee and has contributed to Republican candidates. I would inform you that there are people that believe that IRS targeting has gone beyond conservative groups in the 501c4 and into other areas of the IRS. I would like to inform you that the deficit of trust goes beyond tax-exempt organizations. And I'd like you to note that when 100% of those targeted tax-exempt organizations turned out to be conservative organizations, and people start threading their other problems with the IRS into their Republican affiliation or conservative affiliation, it begins to create a connect-the-dot situation that has created an enormous deficit of trust, and I appreciate your willingness to address what is coming up. I do want to yield the balance of my time to the gentleman from Ohio, Mr. Jordan.
And with that, we're going to give the gentleman from Ohio 2 full minutes to conclude.
And I'll definitely, I appreciate it, Chairman. When do you anticipate completing the C4, looking at the comments and making a decision on the proposed rule relative to C4 organizations?
Again, that's difficult to project. We obviously have a lot of comments. We need
You're obligated to look at all those comments.
We're going to need to have those. We will hold a public hearing where the public and members of Congress can testify. If we are going to significantly change, which is possible, certainly, the regulation, we would probably have to republish it. So as I've said in the past, I think it's unlikely we're going to get this.
Do you have an opinion on the proposed rule now? Prior to looking at the comments, you said you haven't looked at them. Do you have an opinion on the rule now? Do you think it's a good rule? Do you think you're going to stick with it, or do you think you're going to change? You being the head of the IRS.
Head of the IRS, my position has been that I'm going to keep an open mind about the entire thing so that I can look at all the comments fresh. I wasn't here when the regulation was drafted, so I don't have a dog in that fight. My commitment is that any regulation that comes out ought to be fair to everybody, it ought to be clear, and it ought to be easy to administer.
Let me go back to, I got 50 seconds here. Let me go back to where I was earlier on your testimony. You indicated that you took this directly from Mr. Fitzpain's letter, lifted it from his, inserted it into yours. Do you view that as plagiarism, Mr. Koskinen?
If I were publishing it for credit of one kind or another, I would, in terms of...
You think you should have cited where it came from?
Pardon?
You think you should have cited that it came from the Treasury Department? I mean, your answer to me earlier was, we're independent. I view my role as independent. No one talked to me about the C4 rule prior to, during the nomination process. No one at the White House, no one asked me about it prior to being nominated, going through the confirmation process. And yet you take directly from the Treasury Department their exact language regarding the C4 rule, insert it into your testimony, and then come here and say you're independent. That's our concern.
I continue to think, if I find a good idea somewhere and I think it's appropriate to put into the public domain, I'm happy to do it.
I understand that, but you specifically told me you didn't do that you work independent, you put together your own testimony, and you didn't work with the Treasury. No one influenced you on the C4. Right. No one asked you about it when you went through the nomination process.
I'm independent of this committee. If you have a very good idea, I'm likely to adopt that idea.
You know what? We have a good idea. We have a real good idea. Give us every one of Lois Lerner's emails as soon as possible.
And we're going to work on that together.
I thank you. We now go to the gentleman from Maryland, Mr. Cummings, for his close.
Thank you very much, Mr. Chairman. This hearing has been very helpful in that I think we were able to some degree, focus on an IG report. The IG had 9 recommendations, and they have all been met. And I want to take a moment to say to the IRS employees who are watching us, and to you, Mr. Koshkian, I just want to thank you for your service. You all have one of the toughest jobs in America, collecting taxes. At the same time, you have laws that you have to make sure are adhered to. And when people get those letters saying that they're about to have an audit, or they get anything from the IRS except a check, the blood pressure probably goes up a little bit because they are concerned. And the reason why I say all that is I want to go back to something that Mr. Lynch said, that I think that when you have any kind of breach of trust, what happens is that it makes everything suspect. And I know that you have come in to try to restore that trust. And it's not easy. And on the one hand, you come in and you've taken up where Mr. Werfel left off, and I give him a lot of credit, as I know you do.
Right.
And all those employees who are working hour after hour and giving their blood, sweat, and tears to try to make this work. But then no matter what happens, there's still a search for what part Ms. Lois Lerner played in this. And she really brought on some of her own problems, to be frank with you. And so you got the committee trying to get to that. And in part, in reality, it is relevant to a degree. And that is so that we figure out what happened so that we make sure it doesn't happen again. And so that's significant. But I don't want that to take away from what you all have accomplished, because I know that it has not been easy. And there's been much talk about the regulations, the proposed regulation. And, you know, I was just looking here at the recommendations of the IG. And he recommended to IRS Chief Counsel and Department of the Treasury that guidance on how to measure the primary activity of IRC and 501c4 social welfare organizations be included for consideration in the Department of Treasury priority guidance plan. That's what the IG said. And somebody here, I think it may have been Mr. Jordan, went on and on and on and on and on and on and on about how nobody's happy. Well, in my 32 years in being in public life and looking at laws and regulations, I can tell you most people aren't happy about something in a law. That's the way it is. And so I want to make sure, the thing that I want to make sure does not happen is that there is not a chilling effect on the IRS and the job that they are supposed to do. I don't want them to be in a position where they become so paranoid that they don't do what that we, the Congress, have mandated that they do. And so I'm hoping that, again, that the employees will do their jobs, will continue to do the very best that they can, use their best judgment, hopefully, and I pray that they will, leave their political hats at the door so that Americans, all of them, will be served the way that the Congress intends for them to be served. And that is everybody treated fairly and equally. And with that, I want to thank you.
Could I just comment for a minute?
I hope the chairman will give you a second.
And I would have responded to the Congresswoman from Tennessee that even with our restrained and constrained resources, we'll do 1,300,000 audits this year. Some of them are going to be Democrats, some are going to be Republicans, some are going to belong to one organization or another, some will go to church, some won't go to church, some will have been a meeting 2 months ago. It's important for us and critical for the taxpayers to understand that no matter who you are, what your background is, at this point, dealing with the IRS, when you get an inquiry from us, it's because of something in the material you filed. And you're going to be treated fairly. And if anybody else had the same information in their material they filed, they would get an inquiry from us. It may mean we need more information, we need an explanation, maybe there's been a mistake. But across the board, I think the point is well taken. If there is a decline in trust people are all going to try to figure out when they get a letter from the IRS, why are they getting it? And what I want them to be comfortable with, and it'll take time to reassure them, they get that letter because of something they filed in their returns. It has nothing to do with who they are, nothing to do with their political beliefs are, nothing to do with who they voted for in their last election. And I understand that for some people, that's hard to believe right now, but that is our commitment, and that is our goal in the years going forward.
Thank you with that, Mr. Chairman. I yield back.
Thank you. Often for a chairman, it's hard not to bring your past experiences into Congress. Sometimes it's helpful. When I was starting in business, my very first year, I was audited on my income as an Army First Lieutenant. Went in with the paperwork and my fledgling new accountant for my new firm, and turns out that the auditor was a former military officer, and he was horrified that I'd received so much per diem from temporary duty. And he kept saying, but I never got anything like this. It's not possible. And I wasn't a military expert. He was an IRS auditor. And he was just angry as hell that I was on TDY apparently full-time, except for 1-2 days a month, a quarter, for years. I was with an experimentation command. We were always there. Ultimately, I paid no new taxes, and there wasn't a problem. But it was remarkable to me to realize that he came with a prejudice. It wasn't a Republican prejudice. It wasn't a Democratic prejudice. It was a prejudice about the money I got tax-free as a per diem recipient. That's human nature. We're dealing with human beings. This investigation may be about politics, or it may be about human beings. And your charge, of course, is to try to wring out the wrong behavior in both cases. You're charged not just with making sure they don't pick on me because I'm a conservative, or Mr. Cummings because he's comparatively liberal, but also the whole question of, you know, they audit a lot of people who make a lot more money than they do. That's not a get-even time. All of those and more are part of your charge. But the investigation before us primarily is about some past conduct. And I want to put into the record, these are from a previous hearing, but I'll put them into at this point for continuity. July 10, 2012, 2 emails related to Lois Lerner's emails, in which it has in it, Democrats say anonymous donors unfairly influence Senate races. It says, perhaps the FEC will save the day. Now, this includes Holly Paz, Sharon Light, and Lois Lerner in the train. And it also mentions Crossroads GPS and a number of other things. And it particularly says the Obama campaign, and then it's semi-redacted, filed a similar complaint against Crossroads GPS, watchdog groups, and so on. One of the things that we're finding, and it was here today in testimony that you made, it was definitely on a number of my Democratic members, Ms. Spear and others, Ms. Grisham, they've got a real problem with a 501c4 not disclosing their donors. They want 501c4s to essentially not be able to do what they do. They want them to be 527s, another tax category, correct?
I don't know what they want. The 527 is another tax category for political
527s can do all the activities they want to do, political. They just have to disclose their donors. That falls under the Federal Election Commission. The charge this committee has in government oversight and reform includes making sure that we properly allocate resources and authorities where they're supposed to be. In 1959, some 50 years ago, 50 years, more than 50 years ago, 50 years before Barack Obama was elected president, the American people made certain decisions on a 501c4, and the ruling that came out of that stood for all those years. And there was clearly political activity by 501c4s, and they did not report their donors. When Congress created the Federal Election Commission, and through Shays Meehan, McCain-Feingold, and other reforms over the years, changes were made. I find no record that they made a decision, that the American people, through their elected representatives, Republicans and Democrats, made any decision to make 501c4s report their donors or to limit their ability beyond the majority decision that had been made in the rule for decades. It would appear as though through these emails and other activities of Lois Lerner and others, individuals at a very high level in Washington working for your agency made a decision that they were going to do what the FEC was charged to do, but use their authority. I believe that it's been well shown there. I believe that's one of the challenges we face beyond the fundamental investigation of the targeting. If the IRS is allowed to become a wing of the Federal Election Commission, if you're allowed to create a rule, modify rules, because you, the President, or executives within the IRS or Treasury believe that it shouldn't be some way, that they should have to report, and that's the reason for changing a 501c4, which cannot exclusively do politics, but can do some amount of politics, even by your own self-declaration right now, 40%, without reporting their donors, that in fact the IRS is legislating and regulating using authority they don't have to legislate and regulatory authority they don't have that the FEC has. Congress, in its wisdom, and past presidents have in fact provided the rules under which the Federal Election Commission operates and where the disclosure is. Many members of this committee have expressed their willingness and their concern and their belief that the rules should be changed. Whether I share that or not, my concern as the head of this Oversight Committee, and I would hope all of the committees doing oversight, is that you not take it on yourself or anyone that works for you or for the executive branch to legislate a change. That is the exclusive purview of Congress, and reevaluating an existing law 50 years ago, quite frankly, belongs to the courts, not to an agency to conveniently reinterpret something based on who's using it and how and whether it's politically acceptable. So our committee will continue to investigate on behalf of the American people, because we do find the fundamental evidence beyond the targeting of conservative groups that the decision of Citizens United and the growth of the use of 501c4s to do some politics, but not exclusive, in fact, appears to be the reason for action by the IRS. It is within our jurisdiction, it is within our purview to continue that. So in closing, I must tell you, we do want all of Lois Lerner's emails. We do want all of Holly Paz's emails. We don't believe that you've been forthcoming in a timely fashion. We do believe that you have given us what you believe is responsive, hoping we would never get the rest, when in fact, when I issued the subpoena and then reissued a subpoena to you, I did so to make it very clear that our investigation as to emails like this one tell us that we need to look at all of her correspondence for why she was doing what she was doing and who she was doing it with. And with that, it is. No, it's a closing statement. And I didn't ask a question. I made a statement.
Right. I may not agree with all the conclusions in the statement, but it is the Chairman's right to make whatever statements he'd like.
No, I certainly let him answer yours, but this was a statement, and I wanted you to understand where the investigation was going, which is really what the close was about. Mr. Cummings, during the course of this investigation, you raised procedural questions related to Ms. Lerner's conduct when she appeared before the committee on May 22, 2013, and again on March 5, 2014. You had a consultant, Mr. Mort Rosenberg, look into this. He prepared a memo. The Office of General Counsel, in turn, prepared a memo to advise the members of the committee on this topic. I now ask unanimous consent that that memo be placed in the record. Without objection, so ordered.
Do we have it?
It's just a memo from Kerry responding. Mr. Commissioner, I appreciate you were treated well in some cases, and in some cases our members went off topic. You handled yourself incredibly well. We do have disagreements on discovery speed. I'm sure we always will. I do appreciate your being here today and your answering all questions. I did not weigh in when people went off topic, and you handled yourself very well. I would have weighed in if I thought that you were sinking. You were not. So I want to thank you. And is there anything more, Mr.?
No, just that we will provide you with our memo with the, in response to yours, which has 23 experts who will agree with us. So
we can continue to play the tit for
all right.
tat.
No tit for tat. I just letting you know. That's all.
Okay, very good. Thank
Very
you.
well.
And, Mr. Commissioner, thank you. We stand adjourned.
Thank you. Pardon? I'll get this. That's what I get them, and I go, well, I'm going to say that part.
Kate.